Already some of the candidates were appointment in the post of Anganwadi worker and helper, and suddenly the respondent authority issued another advertisement.
Tomorrow.
May
Yes.
it please your lordship. I also pray for listing of litigation from Parliament.
What urgency?
My lord, there is an order of this honorable court. Earlier on, when I had come, that without giving me the reasonable opportunity to cross-examine and etc., PP was being conducted. The honorable court passed an order on October 25th that okay, you go there, raise the thing. If you do not, come back.
All right.
My lord, non-payment of pension, my lord, non-release of family pension, etc., my lord. Matter was last listed 7/3/25. May come, my lord, 14, my lord.
14. Motion. Admission matter. Day after tomorrow is a holiday. Friday.
Prayer for listing of a admission matter. My lord, there is a vacancy in the post of Deputy Inspector General Headquarters. I being eligible, have been.
When was it last listed?
My lord, it was last listed in the prior to Bihu month.
Did it come on 14? 14.
Deeply
Hello,
obliged.
Executive reply has been filed in connection with item number 24 and 25, Malad. Can be brought on record.
When did you file it?
Today, Malad.
Why?
Malad, reply is that, Malad, they have filed in the case
Let it come on Friday.
Malad,
Let it come on Friday along with the additional affidavit in reply.
in fact, it's already filed. If your lawsuit pleases.
You have filed today morning.
Yes.
Why did you file it today? Why not last week? It would have come along with the
In
papers.
fact, they have filed in the Malad, last week. They have
That's
filed,
right.
Malad,
So we'll have it on Friday.
lawsuit.
Friday.
Wait, please.
What is the item number?
Item number 24 and 25, Malad.
24, 25 on Friday. You are for the petitioner.
I am for the petition.
On Friday, coming Friday.
May please, your lordship. I beg to mention item number 51, your lordship. May it kindly be passable for the day, your lordship.
51, 151.
5-1. Consent has been obtained from the other
51
side.
at the request of counsel for petitioner.
Yes, your lordship.
Then passed over for the next.
Obliged.
Prayer for listing of a matter on 8th. Lordship was pleased to grant a status quo till the 7th. 7th being a holiday matter. I requested the registry, but they say it will come up on 9th. 8th day goes blank in between. May I pray to be taken up on 8th matter?
8.
8th matter. At the most. And my lord, there's another matter, transfer matter, where she is required to be released on the 9th. The matter can be taken up on 8th. I filed
Why
the
not today?
petition.
Where is that matter?
My lord, no, it's a new filing. New matter, my lord.
New matter.
New matter.
Bring it tomorrow.
Tomorrow. Bless you.
May I please, your lordship. Lordship, I beg to mention for listing of a writ petition. Lordship, it was fixed on the last occasion for filing of an affidavit by the state. 4 weeks time was given, lordship. It ought to have been listed in the month of February. So can it be fixed on 14th?
14. All right.
Much obliged,
May it please your lordship. Lordship, I beg to mention item number 52 of the daily list.
52.
Lordship. Yes, your lordship.
52.
Yes, your lordship. Lordship, we're praying for an adjournment as the engaged counsel is suffering from some illness, your lordship. We have obtained his-
52 matter stands deferred to be listed.
Lordship, he is for the petitioner.
Huh?
No, no, date may be fixed on 22nd.
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 It's 22nd. Not 22nd, 23rd.
You want to, can it be taken on 27th?
27.
27th.
No. Take a miscellaneous day.
Okay, 23rd.
23rd. Yes.
Deeply obliged.
Yes.
May it please your lordship. I beg to mention for listing of a writ petition on 9th of May.
Why? What is the urgency?
Lordship, the petitioner hearing is claiming for release of family pension for her minor son.
Family pension.
Family pension.
All right. 9.
Obliged.
May it please your lordship. I beg to mention item number 46, your lordship. I'm appearing on behalf of R. Sharma, your lordship. Your lordship, the engaged counsel father has passed away, your lordship. The matter may be adjourned, your lordship allowed.
46.
Yes, your lordship. Lordship, if
It is
it's feasible,
submitted
the
to
matter may
counsel
be
for the
listed again
petitioner
on
in the bereavement.
20.
Matter stands deferred. Listed after 2 weeks. Yes.
Lordship, 20th, if it's possible. 20th of May.
Let him first attend to the function. We are adjourning it for 2 weeks. You can fix a date after that.
Much obliged.
May I please, your Lordship, I beg to mention for listing of writ petition for admission hearing, Lordship.
Admission hearing.
Huh.
What is the matter?
Matter relates to the non-releasing of family pension in favor of the petitioner, Lordship.
22nd.
Your Lordship, I beg to mention for listing, Lordship, matter pertains to pension, Lordship. Any date, Lordship.
Admission.
Admission,
23rd.
Lordship.
Proposal item 1.
May I please, your Lordship. This matter is becoming impact to us, Lordship.
It is submitted on behalf of the council. The matter is being submitted. Writ petition. Petitioner does not wish to press any further. Writ petition therefore dismissed. In practice, the interim order is indicated. Mr. S. Pora for the
3 and 4.
respondent 3 and 4.
Lordship, I am for respondent number 1.
Mr. N. Kulita for respondent number 1.
Item 2.
They were required to have their instructors.
Yes, instructions.
My lord, I am envious. Recently, I have received the copy actually today.
But
I will
no
take
excuse.
instruct-
The earlier council was there. Where is the earlier council? Mrs. Gayan.
Oh.
Where is Mrs. Gayan?
Lordship, she is in next, Lordship. We have received the instruction, Lordship.
Then you share it with the council.
Lordship,
You bring it after 10 minutes. Get your instruction.
The twist then maybe given.
No.
Then
Get
yes.
she has received
No,
instructions.
okay, well, as per as your honor.
She has received instructions. Why don't you? What are your instructions?
After 10 minutes.
What are your instructions?
Lordship, let me senior come, Lordship. Lordship, let my
All
senior
right,
come.
call her.
Can it be fixed at 2, Lordship?
No. 10 minutes. None appears for the petitioner when the matter is called. Matter stands passed over for the day.
Last 4 petitioners are the legal heirs of the deceased government employee, my lord, who died in harness on 8/2/2020. Petition number 1 is the legally married wife, 2 is the minor daughter, 3 and 4 are the parents of the deceased government employee. After death of the employee, the petitioners have approached the authorities, but they were informed that the respondent number 5 claiming herself to be the wife of.
Will issue notice here.
Yes,
Third council for the parties. It's 4 weeks. Mr. A. Chakraborty, have an advocate appearing on behalf of
1, 2 and 3 lots. I may pay.
1, 2 and 3. Mr. Who's for finance? Mr. A. Tolia appeared for respondent number 4. Step since the council represent the respondent, this is the way. Extra copies be furnished within a period of 2 weeks from today. Steps on respondent number 5 by registered post 80 as well as usual course within 1 week from today.
And the pendency shall not be a part of the dispose of the representation.
Just after the returnable date. Pendency of the writ petition shall not be a bar to dispose of the representation filed by the petitioner by the respondent number.
Respondent number 3.
3 lots.
3.
Respondent.
May it please your Lordship. Petitioner was placed under suspension on 1/10/2022. Thereafter extended Lordship twice, Lordship. So he is under continued suspension.
Yes, why suspension for continued period?
I have to take instruction. Lordship.
Please take. We keeping it on 14,
Lordship, 14.
15th, Lordship.
16. Give them
Lordship.
some time.
Obliged.
You will furnish an extra copy to both the counts
Lordship.
by today.
By today.
Heard MST shows. Mr. K.K. Goswami appears, government additional senior appears for respondent number 3 and 4.
Lordship, I am on behalf of 1, 3 and 4, Lordship.
1, 3 and
1, 3 and 4. I'm for
Mr.
2, Lord.
J. Henry for respondent number 2. The councils are permitted to complete their instruction. This matter again on 16th of May. Council for petitioner will ensure service of extra copies within the course of the day on the respective councils for the respondent.
I'm deeply agree.
This petitioner, their staff nurse on contractual basis, working since 2006-7, my lord. My lord, in respect of the other, my lord, employees of the government, my lord, paragraph 50, page 55, they have taken steps for regularization. So the petitioner is also praying for similar.
Yes,
Step.
Mr. Gogoi.
My lord,
Yes,
that I will
Mr.
have to, notice maybe.
But Mr. P.D. Das, Senior Counsel assisted by Mr. Gurgaishan and Mr. B. Gogoi, learned additional AG appearing for the respondent. All respondents, let notice issue returnable 4 weeks. Since the respondents are represented by counsel who the waive. Extra copies be furnished within a period of 1 week from today. Pendency of the part, writ petition shall not be a part to consider the claim of the petitioner by the respondent.
But that was for education department. That means, that was my lord, that policy of at page 55 is of
We are
education.
saying pendency will not be a part.
Yes, please, your lord. Lord, matter pertains to non-payment of my lord, commutation of pension loan, my lord. Kindly see page 54, my lord. Chief Executive Officer Bongaigaon Jilla Parishad forwarded my lord, application to the Director of Pension, my lord, respondent number 5, on my lord, 12 August 2024, my lord. But thereafter no step has been taken, my lord.
Mr. Moore, instructions?
Hello.
Get your instruction?
No, this is the first day today. Today is the first day.
You get your instruction?
Yes, yes.
You will have it on 16?
16.
Mr. K.R. Patgiri appears for the petitioner, Mr. K. Moore, under additional AG for the respondent. MS
Yes, Lord.
S. 414,
Respondent number 2 and 3.
respondent 2 and 3. The respondents will complete their, respondents are permitted to complete their instruction. Let the matter be listed on 16th of May. Extra copies to the writ petition to be furnished within the course of the week. Please take out it.
Obliged.
No, please, your lordship. My lord, dispute involved in this case regarding the my lord, quantum of pension. Otherwise, my lord, the petitioner has been paid pension, but she has been paid lower pension, my lord. Kindly see page 59. Length of service was deducted, my lord. And is there settle issue? My lord, division bench has already settled in Sir Mohammed Fazler Abdi case. As you know, lordship, judgment, my lord.
Okay, heard Mr. M. Islam, Mr. K. Moore. Disposed. You have a copy of
Yes, your lordship.
This stage, notice may go in.
Covered by
Covered your lordship, but so far as his pair is concerned, your lordship, he is claiming for area, your lordship. Your lordship,
No,
the petitioner
no.
husband,
It's family pension, man, not area, man.
family pension.
if it is the quantum of pension, then it is agreeable to us. But so far as the area or the interest, your lordship, this is the
No. Quantum of pension, if you correct it,
Uh.
then you have to give a date from which date you are correcting it. If it is, if the quantum is to be corrected today, then you have to explain why it is not from the date the pension has been started.
thing is that your lordship, he is claiming very belatedly, your lordship. After
That is a
2
different
decades.
issue, but pension is pension.
Yes, sir.
It is for the department to ensure, because the law is settled. I don't know why these petitions keep on
So far
coming.
as the claiming of arrear and interest, it is
No, we
also
are
settled
giving
by
a
the Supreme
similar
Court.
order. We have passed similar order. We have not included interest.
Yes, sir.
Let's move. Okay, to a-
Obliged.
Highly obliged. my lord.
12-5.
And it says borrower for 2 and 5.
May please, Your Lordship. Petitioner participated in the my lord, selection process of Constable GD in Central Armed Police Forces, my lord. Accordingly, he got the cutoff mark and he was appointed provisionally, my lord. The appointment letter kindly see page 66. Page 62, my lord. Page 62, he was appointed. Accordingly, he joined also, my lord. But subsequently, page 67, my lord, kindly see import, my lord.
So what is your prayer?
Kindly see page 67. The appointment has been cancelled for, my lord, verification of biometric data, my lord. For that, they should not cancel my appointment, my lord. They can always verify, my lord. Fingerprint of the petitioner, my lord.
What is a BOO? What is BOO?
Biometric.
Did you get instructions?
Yes, sir. Your Lordship, notice may go, Lordship. His biometrics are not matched. And
Only fingerprint.
verification of fingerprint.
They can always verify, my lord.
Notice have to go, Lordship.
There is no bar to verify, my
I
lord.
heard council for department notice written about 4 weeks. And it says borrower appears for the respondent. All the respondent,
Yes, Lordship.
all
All.
the respondents are represented, notices are waived, extra copy will be furnished within a period of 1 week. Matter will be listed after the returnable date. Yes,
Interim may be considered.
interim.
No, Lordship.
On returnable date, my lord. On returnable date, my lord.
All right.
No, Lordship. His
Interim may be considered. Prayer for interim to be considered of the next returnable date. 8th of 9th of July.
Obliged, my lord.
May I please, Your Lordship? My lord, in this matter, my lord, during the process of the pension, my lord, process, my lord, of my deceased husband, my lord, my husband expired, my lord, and thereafter, my lord, the impleadment order issued by the respondent number 7, wherein said that my husband worked lesser than 20 years, after deducting the 6 years, my lord, overlooking the direction of the Honorable Court as well as administrative order, my lord, I think that my husband is not entitled family pension, my lord. Lordship, kindly have a look on impleadment order page 34.
Sandita Roy.
Yes, my lord. And my lord, another, my lord, I have enclosed the Sanchita Road relied, but subsequently one case, my lord, that is Raful Sarkar, my lord. I have enclosed those both the order. Even my lord, I have filed one representation page 65 and except 14.
What do you say?
Lordship, may I give direction to respond the family pension, I mean, lord, my husband died on 2010, my lord, and till 2022 they have
But
said,
you get your instructions. Let them
yes,
get
my lord.
their instructions.
Short date may be given, my lord.
19,
My lord.
19 May. 19th. Let the respondent, Mr. P.K. Deka, appears for the petitioner, and Mr. S.M.P. and the name appears to the
I'm for my lord, response 6 and 7.
respondent 6 and 7, S.K. D. Neupor,
1, 4, and 5.
1, 4, and 5, S. Goro,
Correspondent number 3.
respondent 3. You're also there?
Yes, responding to
I'm going for respondent.
8 is present.
The The respondents will complete their instructions in the matter and apprise the court. Although notice is not issued, extra copies will be furnished on the respective counsel within the course of the week.
Deeply obliged.
May it please your lordship.
Yeah.
My lord, the petitioner before your lordships, their diploma holder in civil engineering and planning and another called construction engineering. Now, my lord, there were certain posts, in fact, my lord, if your lordship kindly comes to page number 33, that's the advertisement issued by the Public Service Commission. 264 number of posts were advertised in different streams of junior engineer. If your lordship kindly comes to page 34, 6, educational qualification. Junior engineer civil, 3-year diploma in civil engineering from any institute recognized by AICTE. Now, my lord, some of the petitioners are diploma in civil engineering and planning, and some of them are, my lord, construction engineering. End of the day, my lord, as per Director of Technical Education and the, my lord, AICTE, these are one and the same. Now, my lord, we have not been considered for selection. Now, a similar matter was, agitated before this honorable court, my lord. A learned single judge at page number 86 has already declared that these are all one and the same. Lordship, to kindly come to page 86.
Yeah.
Para 16.
Based on some affidavit filed.
No, after a hot contest, the judgment was delivered. Para 16, page 86. The above averments made by respondent number 1, that is Government of Assam, in conjunction with the report submitted by committee, which was constituted on 18/11/23, clearly goes to show that petitioners who have diploma in civil engineering and planning and diploma in construction technology who had submitted their candidature for being considered for the post of junior engineer in pursuance to the advertisement dated 19/11/19 would also have to be considered for the said post, as the diplomas they possess are equivalent to diploma in civil engineering. Thus, the petitioners are having requisite qualification for the post of JE Civil in terms of advertisement. This was in case of Millard Public Works Department. Now we are concerned with PHC. And I'll just show two more things, Millard. If your lordship would kindly come to yes, page 77, Millard. This is a letter by Director of Technical Education. That's the specialized thing, Millard. This was in 22. Kindly see, with reference to the subject cited above, I have honor to state that as per AICT notification and Assam Government Office Memorandum mentioned on the reference, diploma in civil engineering and planning may be considered as equivalent to diploma in civil engineering. Diploma in civil engineering and planning belongs to the core or major discipline of civil engineering, which is as per nomenclature of UG and PG degrees in engineering. Kindly see, my lord, the broad category civil engineering, all this come. Building and construction technology with which we are concerned, then civil engineering and planning, then civil engineering, civil and rural engineering, these are all civil engineering. And I wonder one thing, my lord, what business APSC has got to do in these matters? The requisition is from the state. If the business of APSC is to make selection, on what basis they are sitting in appeal over these, my lord? Are they experts? Just see, my lord, how these people are being...
What orders have been passed by the APSC?
No, APSC has not selected us, not considered our case. Now, my prayer at this stage is, my lord, there are vacancies available, there are 10 petitioners, 10 posts should not be filled up.
No, that let us hear, let us find.
Yes.
What do you say?
Lordship, this
Who has given the requisition?
Requisition was given by the department,
Which department?
Irrigation department, Lordship.
irrigation.
Who for irrigation?
No, public health
Oh, sorry,
engineering.
public health department, Lordship. in this case.
Huh.
And
Public health.
Lordship, in this case, Lordship is otherwise not maintainable for non-joint necessary party, Lordship. Lordship kindly see, Lordship, the parties which they have made, Lordship, they have paid for setting aside that appointment and their inclusion, but they have not made party holder selected candidate, Lordship.
So some of them are there,
So,
7.
but some of them, who are they, Lordship? How they would be aggrieved, Lordship? If that if the select list has to be recasted, who would be out and who would be in, Lordship?
Where is the select list?
Yes, sir. Now, my lord, the page 71. How do we know, my lord?
Result
Kindly
is
see.
62, Lordship.
Please come to, sorry,
62, sir.
1 second, 1 second.
62, Lordship. Annexa G, Lordship.
Yes, page 56.
56.
56.
56.
And the result is at page
While
62.
shortlisting, my lord, page 56,
Hmm.
these are the shortlisted candidates. Here our names do not appear.
No,
How do we
these are-
know?
These are the shortlisted candidates.
Huh.
Page 62, Lordship, result.
Page?
62. And paragraph 62.
Copy of the result list. Yes, 62. Yes, correct.
You are
There are
in
total
open, all
number,
in open
No, no, my lord, we are not.
there are total
No, I'm sorry, 1 second. My lord, we may not, these people may not be necessary because they have been selected because they are having civil engineering. So in the ultimate analysis, my lord, there are vacancies are available. That's why in representative capacities we have made. And the Supreme Court judgment is there that I need not make all of them parties. My lord, it is not a fun. You will do a mischief and the citizens will suffer. For you're wrong, why should citizens make all the parties?
then you cannot float the procedure by prescribed by law.
I'll kindly see there is a
How
judgment.
many,
not a-
posts? How many posts are there?
According to us, my lord, there are many vacancies are available.
Yes, what do you say? The
The
parent department?
department will say why APSC is so anxious.
Because Lordship, what happened, Lordship, in this case, Lordship kindly come
What
to
what
the
is the
advertisement.
requisition?
But
Requisition
their
given-
business is to make the selection. There is nothing beyond that.
Requisition is given for
We will
selection of.
confine, Lordship, within our limitation. Lordship, kindly page.
No, first answer the question. Requisition is given for how many posts?
264, Lordship.
And how
Total.
many have been selected?
Lordship, for civil engineering, 212 posts, Lordship. Lordship, page 33.
No, where is the requisition?
The requisition, I'll produce, Lordship.
So, but you said 264. 264 in which post? Which department?
Lordship,
Which branch?
in PhD civil
Page
engineering,
33.
there are 212, Lordship, in civil.
Page 33,
33.
page 33, annexure A. Junior engineer, civil, mechanical, electrical, chemical under public engineering department. Number of posts 264.
Total. And in civil engineering, Lordship, 212.
No, sorry, we are unable to.
The page
see.
33,
33, yes.
Lordship, number
Civil.
of posts,
Junior
264,
engineer civil,
civil, 212.
2-1.
And the petitioner are concerned with that 212 post, Lordship. And we have recommended by the annexure 62, Lordship, page 62, that 212 post has been, Lordship, recommended, Lordship. And on 16/2/2025, appointment were made, Lordship.
Appointments made.
Made, Lordship. Paragraph
yes.
15, they have stated. Thereafter, without making that selected candidate, I don't know, Lordship, it is not beyond of my comprehension.
Yes, these appointments are made.
Yes, my lord, we say there are vacancies. If necessary, we'll see, my lord. No, lordship will kindly see, is it a fun to make 264 respondents a party?
We are not,
There are unemployed.
we are not on that.
Hmm.
The question of challenging them will arise if there are only 212 posts.
No, my lord,
and
what
you are
I'm
claiming-
saying is, we have made some of them as parties in representative capacity. Lordship knows the judgment of the Supreme Court, where Supreme Court says in such a situation, if in representative capacity, some of them are made
How
as
many
parties.
petitioners are there?
We are 10,
10 petitioners.
yes,
But you say there are additional vacancies.
yes. Let department will say, my lord.
Total 212 posts are there, Lordship, as per this, and 212 people have been selected.
All right,
So-
my lord, for interim relief, lordship can keep the matter on some other date.
We'll issue notice at this stage.
Yes,
Yes, sir.
my lord, I want one conclusion from your lordships in this matter. Now, whether a selecting authority has right to decide the qualification. This point I've been putting to this honorable court time and again, my lord. It is the requisition will be by the government. Government will say what is the qualification required. Now, is it the function of the APSC to find out what is the requisite qualification? My lord, as we understand,
We'll examine. that.
yes, that aspect. My lord will kindly make it clear whether APSC has got the authority
Yes.
to go into the question or delving into the question as to what would constitute civil engineering, or it is the expert, that is AICTE and Director of Technical Education.
In the face of the
Yes.
clarification given by AIC.
Yes,
Lordship, may I pray to record the query posed by my senior counsel on the record? I will reply on that.
Right.
Because we have
We are
selected
issuing notice at this.
on the
regard.
requisition of the PAC, Lordship, nothing more than that.
Mr. K. Chaudhary, the Senior Counsel, assisted by N. Mr. TP. Pro appearing for
As per 2, 3, and 4, Lordship, APSC.
2, 3, and 4. Mr. R. Gugoi for
Respond number 5, Your Lordship.
respondent number 5. The petitioner have put to challenge
I am for
The-
number 1.
MS Borua for respondent 1, Mr. Tovildar for
number 6.
respondent number 6. The petitioners have put to challenge their non-selection undertaken.
Basically, we have challenged our non-selection.
That's right. Non-selection by the APSC, rejecting the candidature of the petitioner in the process of selection undertaken for appointment to the post of junior engineer within brackets civil under PHET. Stop. The petitioners claim to be diploma holders in
Civil engineering in planning, civil engineering in planning,
civil engineering in planning
civil engineering and planning, and my lord, construction
and,
technology.
construction technology. Stop. It's the submission of the learned senior counsel that this diploma in within quotes civil engineering and planning quotes closed and again quotes construction technology quotes closed have been held by the State Council of Technical Education. Sorry, have been held by the AICT to be equivalent to civil engineering. So, is the submission of the council for the petition that this issue has already been dealt with by coordinate bench in WPC number 2064 of 2023. So, notwithstanding that, the selection of the petitioner, the petitioners were not selected purportedly on the ground that they were not qualified as the advertisement had indicated. There is the advertisement,
Yes, madam. Page number 33,
33, as the
and relevant portion is at page 34.
had indicated diploma, had indicated education qualification as a diploma in civil engineering from any institute recognized by AICT for the post of junior engineer within brackets civil. The question which the learned senior counsel has posed before this court is that notwithstanding the clarification issued by AICT by communication dated, where is the AICT clarification?
Yes, my lord. 1 second, my lord.
Dated so and so, as well as the finding by the coordinate bench WPC so and so,
From DP to
The
APSC.
APSC.
Football, 77.
as the authority who's required to proceed to selection
Hmm.
has refused to acknowledge or accept the qualification obtained by the petitioners. Stop.
My lord, at page 77, there is a reference of the AICT letter, my lord. At page 77, DT's letter, Director of Technical, there refers to two AICT letters. One of 23/10/20 and other is
A-
28/4/70.
AICT notification which finds reference in page number 77. It is the submission of the council for the petitioner
Different from
where the
AICT
AICT, which is
connector.
the premier authority, statutory authority, which lays down the
My lord, I'm sorry, my lord, page 88, AICT memorandum, page 88.
page 88. This is not by AICT, this is by Director Technical Education.
Yes.
Right.
No, adoption of, my lord, AICT, because there is a requirement of adoption.
Refers to adoption of AICT notification as is reflected in page number 88 of its memorandum. So, the council for the petitioner submits that when the educational qualification has been prescribed by the AICT and which has been adopted by the state, and the PHED is the requisitioning authority, is the authority which has requisition, which has sent the requisition for selection in post of so and so numbers, junior engineer, the APHC cannot prescribe or redefine the qualification. This is contrary to law. Thereafter, the circumstances, inaction of the respondents in, or the action of the respondent in rejecting the candidature of the having heard counsel for the party notice, returnable 4 weeks. Since the councils are represent the respondent, notices are waived, extra copy be furnished within a period of 1 week. Steps on respondent number 7 to 10. 7
My lord, we'll have to take steps to
16.
the department, otherwise we do not have the.
7 to 16 shall be undertaken through the department, through the respondent number 5. Copies shall be served to the office of the copies will be furnished to the office of respondent 5, who in turn will intimate the respondents number 7 to 16 at their respective places of posting. Let the steps on respondent 7 to 16 be undertaken within a period of 2 weeks.
3 days from today, my lord.
3 days.
No.
1 week. We'll give you
Okay.
1 week.
One. My
Prayer
lord,
for,
interim order will be considered after the department takes instruction.
prayer for interim will be considered on the next returnable date, by which date the respondents are expected to complete their instruction. Let's consider again on. We'll have it on 9th of June.
But the issue of maintainability for non-resident of all the parties may be kept in open, Lord.
You raise it.
Lordship may be observed, Lordship. Otherwise,
Why?
you may be not permitted, Lordship.
No, why is it necessary?
If I not raised, Lordship, at the threshold, Lordship, would not be permitted to.
Who says? Under what provision? We are
Lordship.
issuing notice. We are not admitting the matter.
Lordship.
You raise your issues.
Lordship.
My lord,
Raise
my
it.
learned friend should know, my lord, non-danger of necessary party is never fatal.
All right.
It's a brief CPC.
I'm sorry. On the 34, 2000, my learned colleague CGC, Onota Gansi has appeared. And then subsequently, actually, I am instructed by Deputy. And anyway, today he sees in other word, and he has got an order, instruction. And I want to submit it. Yes. Actually,
Have you submitted the VR?
My lord, I had gone there on 3rd of May to submit it. They refused it, and what has happened is today morning, Lordship will find they issue a relieving order. And one, my lord, one paragraph I'm just placing before Lordship. Para 201, Lordship will have. This is the relieving order given to me today morning. Lordship will find the date down below on the seal.
Yeah.
They try to relieve me just to frustrate the proceeding, and Lordship will have para 201 of the judgment I had given, my lord.
I could not take out the whole paragraph, it's around 140 pages. I am yet ready today also to submit my VR papers. Thus, the mere conduct of parties aimed at frustrating the court proceedings or circumventing decisions.
Why
depend
are you
without-
challenging the transfer order?
My lord, what had happened is when I made an application, my health condition and my mother's health condition were not allowing me to proceed on.
Where is the transfer order?
Lordship will find at page 21. Prior to that, Lordship will find at page 19 my application, even before the transfer order was issued. Then at page 21 comes the transfer order, the last man.
Where is your serial number, name?
Still 20, my lord.
20.
20. My lord, I am being pushed to Delhi. Not a bad place, it's nothing.
Hmm.
But the thing is, I cannot leave my mother who's on her deathbed. I also have my medical problems, which are at the following pages. Therefore,
But
my lord, I have decided to
see-
go for voluntary retirement.
No, you go for voluntary
My lord.
retirement, but then there will be a process. That process will take some time.
My lord, that takes
That
some
cannot be a way to
No,
bypass
Lordship will
the
Lordship
service
will kindly
requirement.
have page 34. Their proceeding, there, my lord, standing order.
What is that?
Page 34, the last one, my lord.
Hmm.
Who are due to retire within 2 years, the account from may be considered for terminal posting to his place of preference or nearby police station or region.
How
All
many
I-
years? How many years have you got?
My lord, I am proposing a retirement in 2026.
You're proposing it.
No,
Have you
I was trying to file it. They have refused it, my lord. This Lordship will find. This was the application I was trying to put in. They even refused to accept it, and on the day of the instructions,
Mr. Counsel, you are better placed to advise your client
But
how
there are-
to send proposals which are refused by.
no, my lord. On
You,
earlier
you,
occasions,
you
I did
know
not
that
bring,
there are better ways of doing it.
and I do not have the judgment on me as of today, but there have been occasions where this honorable court has directed for the filing of the retirement application and for them to consider it within a fixed time frame.
So there may be on different cases. Here is a case where had you are referring to this particular order,
My lord.
particular clause where you are sought to be transferred. Where you say that terminal posting
Yes.
at place of choice.
That is why I was referring to page 19, my application before my posting was being done.
Has it been accepted?
But they took the application, then they have not acted on it.
Did you
So
is it one of your prayers that the application for voluntary retirement is not a matter of right? It will be considered by the authority.
after 20 years of service without a disciplinary proceeding, usually not retained.
Not. But you have-
Usually not
you
retained, my
have to
lord.
call out a right. You have to call out a right to the fact that because you have submitted, you cannot be transferred until it is.
No, it's not. Transfer cases are never matters of right unless and until there is a prohibitory law.
That's right.
Now, this standing order being a part of the, my lord, issued by the Director General under the CRPF Act and rules where he is empowered. This honorable court has also held that it holds that statutory power of a delegated legislation because the DGCRPF has issued it. Now, a man who is frustrated enough to file in a voluntary retirement when he has just completed 20 years of service, has got more than 10 years of service left. It requires a consideration is all I can pray, my lord. He is aged at 33.
It will be considered, but that will not.
Till the consideration comes, my lord, let them not post me out. If they can consider that, okay, he's voluntarily retiring and we do not need to post him out now. That
What is
it may not be a
time
direction, but it
required
will be-
for consideration of your prayers? Yes, Mr. Chaudhary,
My lord, actually, whenever
we'll request Mr. DSGI to get the instructions. Mr. R.K. Dev Chaudhary. See, this man appeared to have filed an application for voluntary retirement. Meanwhile, there was a process for transferring him out. Appears to be that he had submitted some application. Now he is referring to this terminal posting clause to say that had his application been accepted and processed, he is proposing to retire on 26. Now, the problem is that the department perhaps did not accept, or it had accepted but had not considered the voluntary retirement. Meanwhile, a transfer order is issued. So on the last occasion, was an opportunity granted to the learned CGC to obtain
Order is
instruction.
28-4.
Now, apparently the department is of the view, and quite correctly, that voluntary retirement and transfer are two different issues. Meanwhile, they have released him today.
Today, on the top, movement order from DB. We will have 10 days time to report to the other place. Otherwise, they have to take a report.
On Monday, Lordship.
Monday. Keep it. But don't give effect to the transfer order.
He has got 10 days. He has got 10 days.
To join there, I have got 10 days.
Okay. Monday. Monday is a holiday. We can do it at the earliest on 13 or 14. 13.
13.
13. Matter be listed again on 13. Enabling the learned DSGI, Mr. R.K. Dev Chaudhary, to update his instructions in view of the release order having been issued by the respondent authority. The release order reflects that the petitioner has given 10 days to join in his new place of posting. Release order is issued today, that is 5/5. Accordingly, matter be listed again on 13th as agreed to by both of them.
Very competitive.
13th.
They are refusing my formal application for DR.
Meanwhile,
Let them
he is making an allegation that you are refusing to accept his voluntary retirement paper. You get instructions on that.
Yes.
Also.
Publish.
Yes.
In this case, the petitioner was awarded as Law Division Assistant in the year of 1987. Then he was promoted to the post of Senior Assistant in the year of 2030. Then she was again promoted to the post of Supervisory Assistant in the year of 2022. Now, the respondent number 8, who was initially appointed in the year of 1991 as divisional assistant, law division assistant. Then, my lord, he was appointed on senior assistant on 2/1/2016 and supervisory assistant 6/5/2022. Now, the post of revenue solicitor was fall vacant in the establishment of the deputy commissioner, Corpora. Then an advertisement has been issued, page 42.
Yeah.
And in response to the said advertisement, altogether 6 persons, including the petitioner and the applied. Now, so far as the service rule is concerned, it is rule 11(5), clause 5.
11/5.
Yes, sir.
Yes.
Clause 5. In the revenue solicitor, cadre of the seniority shall be according to the cadre date of appointment. So my appointment is 1987. He was appointed in 1991. Apparently, I am the senior.
Yes, you're for the which post now?
revenue solicitor.
Revenue Solicitor.
Yes, my lord.
You are claiming promotion to the post of Revenue Solicitor.
Yes, my lord.
You are appointed as
Originally appointed as lawyer revision register in date of entry in the service.
this particular seniority is to be maintained in the post of Revenue Solicitor. Huh?
Now, here, date of entry in the service, my lord. You also kindly see, in the revenue solicitor,
Hmm.
cadre of seniority shall be according to the date of appointment.
Appointment in the post of Revenue Solicitor. Huh?
It means initial appointment.
On what basis are you giving that interpretation? This is seniority to be maintained in the post of Revenue Solicitor.
Yes. But
you see the other one, serial number 3, 4.
yes, yes.
3 is
Supervisory cadre
Ah.
seniority shall be according to the position in the select list.
Right. Position in which post? In the post of supervisory assistant cadre.
My lord.
That is how the seniority will be determined.
My lord.
Assistant, head assistant cadre, seniority on the date of promotion.
Supervisory. But here, promotion what is not there. Here
Not-
you also kindly see.
No, not there because I think Revenue Solicitor there is a direct recruitment
Promotion
there.
has what is not there. They only mention that date of entry in the service, madam.
No, it doesn't say date of entry. It says date of appointment.
And that date of shall be according to the date of appointment. That is, my lord. Initial appointment is to be considered. Otherwise,
Now you come to the point for the rule regarding recruitment to the post of Revenue Solicitor. Rule 6.
if confirmation of a member
Rule 6. Rule 6.
or laws division register.
No, Solicitor. Rule 6.1.
Yeah.
Recruitment.
Yes. By selection from the amongst persons who must have served for at least 15 years in the deputy commissioner's establishment can have experience in different branches, in general and the revenue branches in particular.
Selection, not promotion.
But however, it should be if you also kindly see graduation list also.
You may be senior, but the rule does not say seniority is the criteria.
Then, my lord, you'll also kindly see there is also provision to file an appeal to the government. Let the government clarify it. We allow to file an appeal to the government, and he will clarify it, my lord. Within 1 month, the government will decide. 12.
Where is the provision for appeal?
12, my lord. Every member of the service shall have the right to appeal from the order of the deputy commissioner
You file an appeal.
to the that observation within 1 month. I will file it. It is to be filed to the government.
Where is the order of promotion?
Order of.
Where is the impugned order?
Yes, it is the order, my lord.
Page number? It's not here.
It is there. Let us know will come. Let it. Not furnished, but let us know we collect it. But most important thing, my lord, during the code of conduct, the appointment has been made. It is made on 9. Election notification issued on 2.
But heard, Mr. Why do you need an order from the court? You go and file an appeal. You file an appeal.
It is a person order.
Huh?
It is a person order within 1 month. I will file within one month. They will decide the matter.
You file it, we'll record it that you're withdrawing the petition
No,
to
my lord,
file an appeal.
order.
Why should there be an order when there's a statutory provision? We'll dismiss it. We can dismiss it, then you can go and appeal.
My lord, for our it was to be disposed of, my lord. It will
Heard
be
learned
better.
counsel for the parties. Petitioner is agreed by the promotion of private respondent to the post of Revenue Solicitor in the office of the
Deputy Commissioner, District Commissioner, Corporate.
District Commissioner Arbitrator by order dated 9/4/2025. counsel for the petitioner has put to challenge the process of selection and the appointment given to the private respondent on the ground that it is violative of Rule 11. Rule 11(5). It is sought to be urged by the petitioner that the seniority in the caterer of revenue arrested it is submitted by the counsel for the petitioner that the petitioner is senior to the private respondent and therefore it is this case which ought to have been considered. Stop the same was not done, ignoring his seniority of a respondent, a private respondent. Therefore, he has put to challenge the order stopped. During the course of the hearing, counsel for the petitioner has placed before the court the order dated 9/4/2025, which he could not procure at the time of filing the writ petition. Stopped by this order, the private respondent has been promoted to the post of revenue arrested. Mr. D.K. Goswami, learned counsel representing the respondent, has pointed out that there is a statutory appeal under 12 of the order having been passed to the deputy commissioner. The service rules provide that an appeal can be filed to the deputy commissioner. Sorry, to the commissioner. Chief Secretary or Commissioner?
It is commissioner.
Commissioner.
12.
The Commissioner. Stop. Therefore, the petitioner ought to have filed an appeal. And having heard counsel for the petitioner, it seems that there is a provision for filing an appeal under Rule 12. Stop. Appeal may be filed to the Commissioner from orders passed by the deputy commissioner. Since the impugned order dated 9/4/2025 has been passed by the deputy commissioner, appointing the private respondent to the post of revenue arrested. This order is an appealable order for which an appeal may be filed before the commission. So counsel for the petitioner also fairly submits that he may be permitted to file an appeal before the commission. So accordingly, writ petition stands closed, permitting the petitioner to file an appeal before the commissioner against the impugned order dated 9/4/2025, whereby the private respondent has been granted the seniority, the appointment to the post of revenue arrested in the office of the commissioner, deputy district commissioner for so,
Commissioner may also clarify.
Such an appeal is filed. The commissioner will dispose of the appeal expeditiously and by a speaking order and a copy thereof be served on the petitioner. Petition accordingly disposed.
The commissioner to clarify the rule.
Speaking order. You urge before the commissioner, you file your appeal and say that may be clarified.
Within 1 month.
No time limit is specified under the rule. We have said expeditiously.
Second, 13.
My lord, the petitioner is an employee of LIC Housing Finance Limited, my lord, in the cadre of Associate Chief Manager, my lord. The petitioner was joined in.
Who's for the LIC? No standing counsel.
Yes, your lordship, I have not found any.
Then we'll have to issue notice today.
Yes, your lordship. By that time, my lord, may I pray for stay the transfer order, my lord, till.
No, not like that. You have to serve copies on the LIC.
My lord, otherwise the petitioner will have to go, my lord.
You'll have to go subject to the outcome. We'll make it subject to the outcome of the writ petition.
But this is malified, my lord. On the ground
have
of
to hear
malified
it.
evidence.
You have to serve copies. Some office must be here. Where is he posted?
Here, now he was transferred to Kolkata, my lord.
From where?
From Guwahati, my lord.
So
Now he
Guwahati
is in
office, you have not even arrayed them as a party. Where is the Guwahati office?
Guwahati office is Pan Bazar, Phasi Bazar, my lord.
Then you have not arrayed it as a party.
My lord, in that case, may I pray for taking up this matter on Friday, my lord? By that time, I will serve a copy to the office, my lord.
You serve copy Friday
Yes,
at
my
the
lord.
request of counsel for the petitioner, enabling him to serve advance copies on the respondent in view of the interim period made before the court. It's on Friday.
Obliged, your lordship.
May it please your lordship. My lord, before I proceed in this number, my lord, just now my friend in item number 11 has placed a submission that there is a provision for appeal against the appointments of revenue Sestadar, but his argument was promotion. So, my lord, but your lordship has held there regarding there is no provision for appeal when the selection is bad in law, that your lordship judgment is there. In the same case of my lord,
No, which you are referring to this matter?
this matter is because just now in item number 11.
Your case is also revenue Sirasana.
Yes, my lord, same. This at para 10, 11, 12. Para 10, 11, 12. I have challenged the selection total. 10,
No, in the earlier matter, he said
promotion. That is why he may be arguing for appeal. But I have challenged the selection when your lordship has held. The challenge in the writ petition is primarily to the para 11. Is primarily to the selection process and the selection committee minutes, which are conducted by the selection of revenue Sestadar. Under the rule, there is no specific provision for filing an appeal under the selection committee member. And para 12, under the circumstances, it is.
There is no order passed.
My lord, there is an. My lord.
There is no order passed with the DC for appointment.
My lord, already passed. I have challenged that because respondent number 5, 2 counts, my lord. Respondent number 5, the rule provides.
Well, let us see what is there in para 12.
Para 12, under the circumstance, it is not appropriate to reject the writ on the ground of alternativity. According to the writ petition, now proceed to adjudicate the issue raised before this. So the selection writ petition was maintainable and it was challenged in this writ petition, earlier writ petition. Now, my lord, if I proceed with my facts of my case.
Yes.
My lord, the case here, the petitioner here has been working in the as the in-charge revenue Sestadar in the office of the deputy commissioner for the last 23 years, 2 months. As in the revenue deputy commissioner's office, revenue Sestadar, he was
respondent who is appointed.
Respondent number 5. Respondent number 5 has not submitted his ACR for last 5 years, which is the requirement of the law.
You are putting a challenge to the selection process.
Selection process.
To the post of revenue director.
My lord.
Now, pursuant to the selection, has any person been selected?
My lord, selected.
Respondent 5.
5.
An appointed one.
Not appointed because appointed 9-4 page. Page is my lord.
So we'll issue notice that you
My lord, he has not joined because of the code of conduct.
Whatever.
Because he has not joined, my lord, page, your lordship will find.
No, he has not joined, doesn't.
Because I am in charge, I am holding the post for last more than 1 year, my lord. And now because he has been selected absolutely against the rules, my lord. I may place in the documents, your lordship will look into it. The advertisement is at page 27. Your lordship has dealt with this matter. Your lordship knows that it is the ACRs are required for 5 years. Page 27, third paragraph, last line. Along with ACR of last 5 consecutive years should reach the undersigned within 20 days from the date of publication of the advertisement. Your lordship has got it. And the rule also says 683. And page 30, your lordship will find. Petitioner has submitted for 5 years. Number 1.
Yes.
And my lord, page 31, he submitted only for 4 years, 18 to 23, serial number 2. And now, my lord, page 36, your lordship will find my notes of the selection board.
Yes.
number two, that is only for 4 years. 22-23. He cannot be selected, my lord. And moreover, I am the senior most. He has not taken over charge. His appointment is at page, my lord, 38. 9-4, and the code of conduct, page 54, your lordship will find I have annexed that. Page 54. No appointments or promotion in the government public service shall be made during this period without prior clearance of the commission. Page 54.
Which one?
My lord, page 54, that is on transfer, it's the posting of, and then it is 9, Roman 9. No appointment or promotion. And the code of
Prior
conduct,
clearance of the commission.
my lord, election commission.
So clearance may have been obtained.
My lord, they have not obtained anything. Nothing has been obtained, my lord. And my lord, that is why he has not taken over charge.
Now, any appointments made in violation of this code?
Yes, my lord.
What is the effect?
Effect, my lord, it will be absolutely bad in law, my lord, because they cannot make the appointments without the clearance. And moreover, my lord, 4 years ACR cannot be considered when the 5 years has to be there. The rule also provides that. And I have alleged malafide by malicious law by name, my lord, just to accommodate respondent number 5.
All right. Heard? Yes.
I am for respondent number Lordship 2 and 3, Lordship. Lordship, GAD Council is absent, Lordship. It has he has challenged the order which has issued by the GMD, as a GAD, Lordship.
Where is that order?
Challenge the order, Lordship, on
Page 38.
page 38, Lordship.
Commissioner Secretary, Government of Assam, General.
GAD, Lordship. And this issue notice, Lordship.
My lord, that is, if they are absent, it's not my fault.
Why is it by GAD?
GAD,
Why is this order issued by
there is a
GAD?
separate council, Lordship.
Why is the order issued by GAD for the post of revenue registrar in Borpeta?
I don't know, Lordship. I'm appealing for the respondent number 2 and 3,
Council
Lordship.
is
Deputy
absent,
Commissioner.
what can be done?
District Commissioner, Lordship.
There is only one council.
Lordship, GAD is appeared by the Lordship P. Nayak, Lordship. Issue notice, Lordship.
And my lord,
Heard, learned counsel for the parties. Its petitioner is aggrieved by the appointment to the post of respondent 5,
5.
the post of revenue registrar in this of the establishment of amalgamated establishment of the district of Borpeta. The grievance of the petitioner is that the selection process which is mandated under the service rule have been flouted. And the fair perusal of the, where is the minutes?
Page, my lord, 36.
Fair perusal of the minutes reflect that the ACRs of 5 years were not. You are 36, you are the
My lord, I am number 1.
number 1. And the other person is
Number 2. That is
Number-
from 20 to 23.
it is submitted that the requirement of 5 years ACR insofar as the private respondent has not been complied with. And this is evident from the minutes of the meeting, minutes of the selection board held on 4/11/2024. So, the further grievance of the petitioner is that the process of selection is not as per the rules. What are the rules? Assam
Assam
Ministerial District
Ministerial
Establishment Service Rules.
Rule 1967. Provision 683.
The present petitioner is the senior most assistant You're what now?
My lord, I am just holding the post of
What
revenue.
is your regular
SDAA, my lord.
Huh?
SDAA. Senior District Administrative Assistant.
The petitioner is presently appointed as the senior district.
Administrative, page 42, my lord, your lordship will find it. Third paragraph, my lord. Mahbub Ram, Senior District Administrative Assistant.
Senior district administrative assistant. And has been given the responsibility to function as in charge. Revenue Service Department. So submitted that is further submitted that the appointment made to the private respondent number 5 has been done, flouting the model code of conduct, which has been issued by the competent authority in view of the panchayat election, ensuing panchayat elections state. So, he therefore submit that the petitioner's the private respondent's appointment be set aside, respondent number 5 appointment be set aside, and he be allowed to continue as the in charge. And the entire selection process be initiated afresh. So, counsel for petitioner also makes an interim prayer that since the model code of conduct is still in place, he should not be allowed to be, he should be allowed to continue as the in charge revenue rest of that. So, there are learned government advocate, Mr. A. Chakraborty, hearing for all.
No, lordship, 2 and 3, lord.
Respondents 2 and 3. Submits that his instructions are not. Further submits that the counsel appearing for the DAD is also not available in court. Having heard counsel for part, let notice issue the matter. Respondents will complete their instruction. Notice, you do one thing. Let the respondents obtain the instructions. They matter. Matter be listed again on 14th May, by which day the necessary instruction will be obtained by the respondent counsel. Extra copies will be furnished within the course of the day. Till the next returnable date, the petitioner shall be allowed to continue or shall not be removed from its present place of posting as in charge of revenue registrar without the leave of the court.
Lordship, may I pray, lordship, SC, GAD in the possibility.
It is submitted by the allowed cabinet that names of standing council GAD should be reflected in the court list. Registry to do the leave.
In terms of an advertisement recruitment for Agnivir, the petitioner appeared in the written test and as well as in the physical gender test and physical efficiency test. Thereafter, the result was published. My prayer is very limited to the extent that the petitioner wants to know the marks secured by the petitioner in the recruitment.
RTI is not appeared.
We can file RTI. Otherwise, I will take your lordship to page 49 for a moment, lordship. Because nowadays, lordship, the examinations are not as it was before. Now, this profile is created, you will have to log in into the profile and you get all the details. He has not done that. If your lordship will see,
Page number?
Page 49. Page 49.
Yes.
Dear candidate, then lordship will come to 2. Otherwise, log into your profile and send your query through feedback option to the concerned ARO ZRO. So he has to log in there.
Yes, your lordship, in that case, your lordship may kindly see 1, approach your ARO, ZRO and explain your problem. At page 48, your lordship will find that he had already approached the ARO, that Army Recruitment Office of Silchar, on 27, prior to approaching the respondent number 2. But in terms of that email, no communication has been made till date, and therefore, lordship, the petitioner is before your lordship. But very limited to your lordship. The mark required by the
You
candidate.
follow the second process,
Lordship.
number 2.
But the second process only says that lordship send your query through feedback. Only in respect only if I want to send it, I want a query. In that case only I will have to log in. But this nowhere says that once I log in.
Why don't you try this and then if required you come back?
In that case, your lordship may kindly keep this matter pending and next week.
Difficult, lordship.
Yes.
Let him
If it is there, lordship, your
Yes,
lordship will close this.
We'll take it up after what, 4 weeks?
Yes.
Matter will be listed after 4 weeks, enabling the Senate Council for the petitioner. Take steps to log into what?
his profile.
Log into the profile held by the Army Recruitment Board. By the Recruitment Board.
Yes, lordship.
To and send queries or requests for the particulars of the marks obtained by the petitioner. Let the matter be listed after 4 weeks.
Lordship may pray for a short day because this will only take a 10 minutes time of the petitioner.
Weeks.
Lordship.
Mr. Arbitrator Chaudhary appears for this.
Nowadays, lordship, in all
Otherwise.
PSC,
Lordship, what is
profile is created and everything is put there.
Lordship, the issue is, lordship, their advertisement says that to maintain transparency and fairness, they maintain it. Lordship, if they don't publish the entire result, like the SSCD does, lordship, where is the fairness and transparency? Yes, yes. Obliged, lordship.
But in this case, I am challenging with peculiar manner and melody rush in cancelling a caste certificate which was issued to me, my lord, some 25 years ago. This lady, my lord, she obtained a PhD in 1998 and holder of a brilliant academic career with 58% marks in MA in Guwahati University, also passed NET PhD. My lord, she hailed from a OBC community. In 2001, got married to one scheduled caste person belonging to scheduled caste, my lord. On bona fide believed that by virtue of marital status, I applied to the deputy commissioner, which is the competent authority, deputy commissioner Nalbari. There is a format of application and deputy commissioner asked me to furnish your father's caste certificate, your husband's caste certificate, your credential, and your other certificate, your family member. I submitted everything. It was verified, scrutinized, then on being satisfied, my lord, the caste certificate was issued. That was, my lord, Constitution 1950 scheduled caste order, my lord. At threshold of the Constitution under Article 341. The caste certificate, your lordship will find at page 29. This was, my lord, 12/6/2001. 25 years ago. This is to certify so much Seniority so and so, district of so and so, recognized as scheduled caste under Constitution, scheduled caste order 50, family originally in the village so and so. This was based on, my lord, the next page your lordship will find at her husband's certificate, which your lordship will find at page 27. Page 27. He is my husband. My husband's certificate that he was a scheduled caste was of 1996, issued by the same authority, my lord, Deputy Commissioner Nolbury. So therefore, my lord, whatever documents I was asked to submit, I submitted at all. I never misrepresented any facts, forged any document, or suppressed any document, or suppressed any material fact, or my credential. And the authorities never said, no, you are not entitled to this certificate. They never refused. They issued this certificate. And this has been granted by the competent authority after due verification. I had no reason to believe that I was not entitled to be treated as a member of scheduled caste. 3 years thereafter, my lord, I participated in a regular selection process, and on being found to be eligible, I was recruited as lecturer in the Assamese department, Nolbury. That was in 2003. I have an appointment letter. Then the remaining facts for your lordship will not take more than 5 minutes to get the facts, my lord. After initial probation, I was confirmed. Then, my lord, without blemish, I completed last 23 years of service. Now I am the head of the department of Assamese department of Nolbury. Next post is principal. Now what happened? After 25 years, I suddenly received a show cause notice, which is at page 34. This is not from the deputy commissioner who issued it. This is from Director Welfare, response number 3, at page 34. Yes. And then the certain important features emerge from this show cause notice itself, my lord. May I read? This was below the date. It was by the Director of Welfare, 38/2023, show cause. Whereas on receipt of a complaint petition regarding your caste being fake, posing here, my lord, who filed a complaint, when filed a complaint, the complaint is the basis, and this was never given, a copy thereof was been never given to me, in spite of my requisition, formal in writing, which I will show later on, my lord. Never supplied to me. And that your certificate, fake is a different word. Fake means I have a certificate in my hand which is forged. This is not fake. This is genuine. This is under the hand and seal of the deputy commissioner. Someone filed a complaint that I am holding a fake certificate. This officer requested superintendent of police, CID, to conduct an inquiry under so and so, so and so. Although no police case of forgery was registered, somehow it was entrusted to CID. And CID, my lord, has submitted an inquiry report on the status of your caste certificate as doubtful. The word doubtful is inconclusive. It may be this way or it may be that way. Same page 34. Yes. Then, whereas in pursuance of directives of the Honorable Supreme Court case Kumari Madhuri Pat and so, I will distinguish this case. Government of Assam Office Memorandum has laid down the procedure of dealing with the matter relating fake certificates. What is this Supreme Court case? An MBBS student, my lord, submit a certificate which was issued not by the appropriate authority and which was not the competent authority to issue. She used it and she got admitted in a medical college. Case came after 4 years. Then court said, all right, now let her pass. But this, no, don't act on this certificate in future. Therefore, I'm reading page 34. Before any action is warranted against you, hereby giving to tag to show cause, my lord. And my lord, show cause, and next page I gave the show cause. Kindly have a look at page 35. Skip the first page. It was given to the director who issued me the show cause notice. Next page, my lord. Top. Page 36, lip 545 sentence. I had submitted my prayer to concerned authority. Accordingly, all my credentials were verified by the competent authority along with supporting document submitted by me, that is caste certificate in favor of my husband, and by considering the factum of marriage as my spouse, Office of the Deputy Commissioner issued so-called caste certificate on 12/6/2001 in my favor. Next paragraph. Upon being granted the caste certificate by the authority, I had no reason to believe that I was not entitled to be considered a member of scheduled caste. Never resorted to any misrepresentation or suppression of facts, and all particulars were duly submitted to the concerned authority for verification. I was recruited under scheduled caste category, provisionally appointed. Then I was I was regularized. My lord, this is the type of show cause notice which my lord submitted to the authority. Then what happened, my lord? This I have stated. Kindly have a look at paragraph 13 and 14 of the writ. Paragraph 13 and 14 of the writ petition. What they did. They issued a notice to appear. Then paragraph 13. Paragraph 13, my lord, will be at page 12. It is not the deputy commissioner.
Were you ever, your status as the SC, this is about SC status, isn't it? So you got this status by virtue of marriage.
By virtue of marriage, and it was given by the competent authority by saying, my case is on a different footing. All right, you want to cancel it in a proper manner. That has not been done.
What is the proper?
And one more question. It
What
was
is the
issued 25
proper
years ago when the present district level scrutiny committee was not even born. It was constituted in 2007. I will come to that, my lord. Can you have a look at page
now
12?
what we want to know is what is the relief you want from the court?
My lord, there are certain questions to be adjudicated upon by your lord. Number,
Like,
certain questions.
no. What is the
Once the competent authority, at the first instance, the day when I applied, he asked me the same office. He asked me to give all the documents and credentials I gave. He could have said no. He didn't say. He on verification he issues it. He issues it. Now same office. The inquiry has not been conducted by the deputy commissioner. It is by the other. Then the other authority, the director once called me for hearing. Kindly have a look at page paragraph 12, page 13.
Oh, essentially, you are saying that that certificate having been given by the proper authority on whatever facts materials they had cannot be cancelled now.
More so, without in accordance with the procedure by giving adequate natural justice.
What is the procedure?
Procedure, my lord, I will have to be given an opportunity for the hearing. Supply me the documents. You said some complaint has been received that you are holding a fake certificate. There is a difference between fake and forged. There is a difference between fake and forged. I applied, never provided the documents, nor I was allowed to inspect. That is what I stated in paragraph 12 and 13. I, in fact, gave a written requisition that kindly supply me the copy. Kindly supply me the copy. Page 39. Page 42, Lordship. Have a look at page 42. All right, you cancel.
All right, let us find out what is your instructions today.
Lordship, I have to take the instruction, Lordship.
You
But
take it.
before that, Lordship,
We'll issue a notice today.
Notice, and my lord, Lordship will adjudicate, my lord, the
We'll decide.
manner in which it is cancelled. If your lordship holds that yes, it is liable to be cancelled and they have done everything as per law, I am out of this court.
All right. Heard Mr. A.C. Porpora,
Be fair
London
enough.
Council, assisted by Mr. F. Mr. J.K. Gulfasi, London. For all.
no, Lordship, I am on behalf of Lordship. Here,
Respondent
the
number
respondent number 2, 4, 2 and 4, Lordship.
2 and 4.
Yes.
Who's for social justice?
Yes, Lordship. RM Das, Lordship.
R.M. Das.
Yes.
Where is Mr. Das? Mr. R.M. Das for respondent number 1 and 5.
5.
And Mr. J.K. Gulfasi for respondent 3 and 4. The petitioner is the
Certificate page.
you are employed. You are employed now.
I'm head of the department, Assam is my lord, Nalbari College.
He is employed as
Next year I am going to be the principal,
head of the department
civil constituent.
at in Asubit, Nalbari College. Petitioner was issued a certificate,
Page 29.
caste certificate, certifying that she belongs to scheduled caste.
12/6/2001.
Page number
29, my lord, dated 12/6/2001. It was issued by the Deputy Commissioner Nalbari,
by certificate dated 12/6/2001.
2001.
and it was issued by the EAC.
EAC for Deputy
Deputy
Commissioner means Deputy Commissioner.
On 13/6/2001. Subsequently, on the basis of some complaint lodged, that the certificate should
Fake.
is fake within quotes. An inquiry was instituted by the respondent authority, and by order dated 29/3/2025, the certificate, SC certificate number so and so, dated so and so, with respect to the notification to cancel the database.
Lordship,
I was not allowed to defend myself.
Lordship, the reason for cancellation is that, Lordship, it is given.
We'll hear you. If you have instructions, you submit or you
Lordship,
get your instructions. The petitioner's remark is that in spite of repeated requests made to the authority concerned at the time of the inquiry, no documents were furnished to the petitioner on the basis
Which are the basis?
the inquiry was conducted.
The whole thing was eyewash.
Copy of the petition alleging that the certificate issued to the petitioner was fake was not submitted. It is therefore submitted that the basic rules of natural justice were violated while the authorities have passed the order. So it is further submitted that the certificate issued on so and so date by the EAC was never questioned by the authority to be fake. Therefore, when the certificate was issued on the basis of material available to the concerned authority, it cannot be termed as fake. Consequently, praise for adequate praise for appropriate orders from the court and adequate protection in respect of the order of cancellation. Mr. Goswami appearing to the government. The other hand, submit that I would like to obtain the required. The praise for
Lordship, 2 weeks time.
2 weeks time.
Well, page 44 is the, my lord, cancellation order.
What is the effect?
My lord, this lordship will adjudicate upon it.
Will adjudicate.
This may not be given effect to my detriment. That is my limited fact.
It is not given to, then you'll be treated to be a member of SC for all time through until the matter is decided.
So now my limited prayer is let this, my lord, order of cancellation may not be used to my detriment, my lord. I want a stay of it. Don't give effect till your lordship adjudicate.
Lordship, regarding stay, Lordship, I have to submit, Lordship. Yes, regarding stay, I have to submit. Lordship, first of all, this order, page 44, Lordship, Annex of 14, that order was passed by the Assistant Commissioner Nolbury, Lordship, empowered to the District Commissioner, Lordship. Now, in that order, it is categorically stated the state level scrutiny committee and the Secretary Department of Social Justice and Empower Dispur Guwahati so and so White order dated so and so order dated 19/12/2024. State level scrutiny committee is of the opinion. That, yes, just a minute. Opinion that one cannot get caste certificate by virtue of marriage and recommendation that the caste certificate of the petitioner Assam is liable to be cancelled by the issuing authority. Now the question is that whether that opinion given by the social justice was not under challenge here in this case, and also the order dated 19/12/2024. On the basis of that order, this order was passed by the additional commissioner, assistant commissioner was not under challenge.
Never given, never supplied to me.
Yes,
I've said
this is the basic order. On the basis of that order, it was this order was passed.
Heard.
This was not under seal in proceed.
Interim.
And therefore, regarding stay of this order, Lordship, kindly fix next week, Lordship, I will produce the instruction. At the same time,
Let
Lordship, the standing council, social welfare, name of the standing council, social welfare should, social justice
Is
should.
it not reflected today?
Yes, no, not reflected. Therefore, they should hurt, Lordship.
No, no, if it is
They have not been,
reflected,
they
then
have
we
not
should
been
find out.
enclosed, all these things which are there mentioned, opinion.
No, what's
Kindly see the impugn order. Is it enclosed, the opinion?
We are
Addition-
trying to pass an order.
Lordship,
Allow us to pass the order, then you make them.
my,
Heard on the interim threat. Counsel for the respondent. Strongly objects. Draft of the interim threat. It submitted that the impugn order dated was passed as per the procedure prescribed by the apex court in Madhuri Party. And at the state level scrutiny committee had examined that matter and recommended and had rendered an opinion that petitioner is not entitled. Considering the fact that the petitioner was issued a certificate as per brackets 12.1, 12.9, 2001, and certain benefits have accrued to the petition by virtue of the Caste certificate, and also from the materials placed to the court, primary basic does not appear to cannot be labeled as a fake certificate. Although the question whether the petitioner could have been entitled to have been issued a certificate is required to be examined by. So, in such circumstances, the petitioner will take benefits which had accrued to the petitioner till date of the issue of the order, that is 29/3/2025, will not be taken away without leave of the court. Lords, we have issued an order saying that the benefits which have accrued to you shall not be taken away without leave of the court. We are not staying the order.
to my detriment, that's what I did. Much obliged, Lord.
Extra copy. Social
We are,
justice,
we
name
are
of the
fixing
social
the,
justice
we
may
are
be.
fixing the matter on on 11th of June.
Lordship.
11th June.
Name of the standing council,
Names
social
of the
justice,
standing council,
social justice.
social justice shall be reflected in the court.
Don't today also. Obliged, Lord.
Yeah, please. The petitioner, my lord, reserve category of candidate, my lord. He is secure, my lord, higher mark than my lord, unreserved category, my lord. And my lord, we filed, my lord, earlier occasion, my lord, the repetition, my lord, at page 155, my lord. Kindly see, my lord. 155 operative person, my lord, page 158. Paragraph, my lord, 6 and 7.
Yeah.
My lord, this honorable court observed that, my lord, they say, if my lord, though my lord, this petitioner is a reserved category candidate, if he secure higher mark than the unreserved category candidate, then he shall not be disentitled. For consideration, paragraph 6 and 7.
We will issue notice today. Heard.
Lordship.
And counsel for the party petitioner, all respondents.
All respondents.
Since the respondents are represented by the counsel, notice survey, extra copy, party, period of party. Any appointments made shall be subject to the outcome presented.
Lordship, it was a recruitment process of 2018.
18.
Notice of 2018, result of
Result was
2021.
declared on 2021.
Then, is there any vacant post?
No, Lord.
All right, prayer for interim on the next returnable date. We'll consider your prayer for interim, if any, on the next returnable date. It's not 7th of June.
Okay.
But my case in a nutshell is that it is a matter of industrial dispute related to the Industrial Dispute Act.
Issue rule. You are challenging the award.
Yes.
Third, counsel for the individual. So you write, this is repetition for the challenge. The award. Dated 24/9/2024, past 5. In Industrial Tribunal.
Yes, the Dibrugarh.
Dibrugarh. Issue rule. With the reports, the whole court. MS.
8 Aludar to
Eight
respond number 1, Lordship.
appears to respond. In examiner, it appears to respondent 1. This is the way respect to respondent 1. Extra copy will be furnished within a period of 1 week from today. Steps on respondent number 3 by registered post AD. No notice is issued to respondent 2 at this stage. This recording.
Published.
Nice, Lordship.
You can appear for 1 and 2.
Lordship. Only for 1, Lordship.
90.
May please, Your Lordship.
Yes.
Here, my lord, petitioner participated in the recruitment process, my lord, for Central Armed Police Forces, my lord. Initially, my lord, her candidature was rejected on the ground of, my lord, measurement of height.
Can you get instructions by next week?
3 weeks required, Lordship.
It's only a question of measurement of height.
No, that is already done, my lord.
That is done.
Now you have to get the result.
Yes, my lord.
Yes, Lordship. Why it is pending?
Get it by next week.
2 weeks required, Lordship.
2 weeks.
Yes.
10 days, my lord.
Right, 10 days, 2 weeks.
My lord, my lord. My lord, 2 weeks, my lord.
It's the matter again on 26th of May,
My lord.
by which time the respondent counsel will obtain instructions as to why the results have not been declared in respect of the regulation. Although notice is not issued at this stage, extra copies will be furnished in a period of within the course of this week. You furnish extra copies. The respondent counsel. It's a nature happens for the commissioner, MS Ed Purva for the CDC.
Published.
Item number 51, the affidavit is ready, my lord. We will be filing it within the week. Then that will cover, my lord, the article.
A date will be given, my lord.
Next week, my lord.
A date will be given.
It is submitted by the council representative. That affidavit in WPC number.
My lord,
1745/2025.
1745/2025. It will be filed during the course of the day.
No, my lord, within this week. we will file.
It is submitted that the other, respect to the other, the date affidavit can be derived.
Possible in the meantime, issue notice, my lord, if it is
not issued.
No.
Notice
yes,
in
my lord.
item number 2282/2025.
It has come up along with item 59. There, my lord, lordship may issue notice. It may come, all three may come together in the admission.
Then we'll have to give it 2 weeks. Let it be after 2 weeks.
Yes, sir.
A date will be given, my lord. Because my lord,
That will be listed on 26th of May.
On 18th, my lord, they may take the examination, they may conduct the examination. That is, murmuring is going on in the department.
Let it be on 16, man.
16.
Man, all
Obliged.
in the admission.
Returnable.
Right.
Reported to the okay. I have an extra copy. Not already published, be published within the course of this.
Interim order is there in respect of item number 1475.
Interim order passed in
WBC 1745 2020.
1745 will continue till the next date, and the effect of which interim order shall also apply to the
All
other
other-
two writ petitions.
Obliged.
It was for challenging a termination order, but a petitioner for the last 7 years has not contacted whether he is interested in this matter or not. Whether
The petitioner submits that he is unable to contact with the writ petition. Therefore,
And
what
he is
you
no
want?
longer in the quarter also, your lordship.
Huh?
He is no longer in the staff quarter also, your lordship, since many years, your lordship.
You are not withdrawing from the matter.
he is not withdrawing from the matter, he is not contacted.
Submit that the council has not received any intimation of the petitioner. So the respondent councils appearing for the respondents have also submitted that he does not reside in the official quarter. He does not reside in the quarter.
He has already vacated
He
the,
has already vacated the quarter. So such circumstances, the petition stands dismissed. Interim orders, if any, stand vacated. Pending I is also dismissed.
obliged, lordship.
Lordship, I am appearing for respondent number 2, 3, and 4, Lordship. We have filed our affidavit in opposition.
None appears for the petitioner on for Mr. Your name?
Islam. R. Islam.
R. Islam for
2, 3, and 4.
respondents 2, 3, and 4. Matter stands passed over. That's voted.
This matter pertains to non-payment of salaries, my lord. The petitioners are employees under the respondent number 1 establishment. So service is complete as per Lawajima Court order dated 34.
Lordship, as per my instruction, as well as the petitioners are not the employee of the respondent 1, Lordship.
Who
They are the-
represents the development authority?
Yes, development authority is the separate entity, Lordship.
I know, but who is the, what do you have an
They
executive
haven't
officer?
appeared, my lord. None appeared.
Is there a secretary, executive officer?
Yes.
Which order are you affected by?
Oh, there is no order, my lord. Our salaries are not being paid. Area salaries and
Chairman.
current salaries. Yes, chairman.
Yes, chairman.
Although notices have been issued and the office note reflects that service on respondent 1 is complete. However, none represents respondent 1. Sir A.K. Goswami, case for respondents number
Madam, may be posted for admission, my lord, after 1 month, giving them
4, 5, 6. So, since respondent 1 is a development authority under the Municipal Act of 1956, the learned government advocate is permitted to obtain instructions through the parent department. Which is the parent department?
The country development. Country development.
Which is the parent department?
Lordship, parent department is the town and country.
Country.
planning.
Town and country planning.
The director is respondent number 4, my lord. Town and country
Through
planning.
the respondent number
The
4,
ex-
director, town and country planning. Let the matter be listed again after 4 weeks for admission. We are permitting you to obtain instructions on behalf of respondent 1
Respondent one.
through the department.
Lordship.
Copy of this order be marked to the office of Mr. Goswami, additional government, senior government. This order be brought to the notice of registrar.
Obliged. The engaged counsel in this case, Mr. A. Dattor, has asked me to inform the court that he is under bereavement. Matter may be.
Submitted that counsel to the petitioner is in bereavement. Therefore, matter stands referred to be listed after 3 weeks. Seek.
Well, I'm appearing for 1, 2, 3, and 4, in the petition. Well, I pray for 2 weeks' time for filing a petition.
2 weeks' time.
Lordship.
Mr. D. Nath, counsel, appearing for respondent 1, 2, 3, 4.
1, 2, 3, and 4.
Prays for 2 weeks' time to complete his instruction. Mr. Todi for
6.
respondent.
We have already filed our affidavit.
We submitted that he has already filed the affidavit. List again after 3 weeks.
I think number 24 and 25, my lord. Probably your lordship has fixed it on Friday, man. There was no other today defect, I think, at 10:30. We have filed our affidavit in reply.
First in the morning only.
Yes, my lord. Your lordship has probably passed order, my lord, today defect, man. To fixing, my lord, on Friday, man.
Yes.
Yes.
Way faster.
Yes.
After my senior Mr. Nayak is on legs in a district court, watch me take up a matter after some time.
What is the matter?
Malat, the petitioners before lordship, Malat, they were master workers, Malat. They were regularized, but due to some spelling mistake or other Malat, they were not given the benefit. They approached this honorable court, Malat. This honorable court asked the director, Malat, transport department to appear personally, and the director himself stated before the honorable court that Malat, the issue is being rectified by the finance department, and observing that, Malat, this honorable court by order at page 12, at page 12, Malat, the
Earlier order.
Earlier order. It starts from page, Malat, relevant portion starts from page 15, Malat.
Lordship, before my learned senior start, Lordship, may kindly have a look at the last order of this honorable court.
Which order are you seeking compliance of?
Malat, page 15.
This is 2007 order.
Yes, ma'am. Malat, immediately thereafter, Malat, they approached this honorable court, Malat, by filing a contempt petition. That contempt petition was closed due to Malat pendency of the review petition. The review petition was subsequently dismissed. And Malat,
Where is the order of the closure of contempt petition?
Malat, that order is not annexed, Malat, but Malat, I have stated that, Malat, in paragraph 4 of my contempt petition, Malat.
You get that order? You get that order?
Right.
Should have been a part of the petition.
Yes. Malat, the writ petition is also pending, Malat. Malat, seeking compliance of the earlier direction. So, Malat, that writ petition, Lordship may take this contempt petition along with the writ petition, Malat.
Writ petition is seeking compliance of which order?
Implementation of the order at page 15, Malat.
That, and you are filing a contempt for
Yes.
compliance.
Yes, Malat, this honorable court, Malat, at page 20,
Right, it is submitted that connected writ petition to file to the paying WPC number
2194 of 2013.
2194 of 2013. That is petition next week.
Okay. Obliged lordship. My lord, I am for respondent number 3.
MS MD Bora for respondent 3, MS
H. Borough on behalf of
H.
Mr.
Bora,
P.
behalf
Nair.
of
Respondent 2.
on behalf of
Respondent number 2. Obliged lordship.
Fix a date.
next update given by the release. Yes.
My lord, earlier, my lord, the contender was my lord Nira Dalogu. It is my lord. Now, my lord, I have filed this petition for my lord as that person, my lord, has retired. So, my lord, I have filed a petition for impleadment of my lord Mousumi Borua, my lord. At page, my lord, at page 9, para number 9, my lord.
Yes. You want to implement
My lord.
of
My lord, Mousumi Borua, my lord.
she is presently the secretary.
My lord.
Submitted that the opposite party, MS Mousumi Borua, is presently a secretary to the government of Assam, Environment and Forest Department. And her impleadment is necessary for due compliance of the directions contained in the order dated so and so, so and so. So, a contempt petition, a impleadment is necessary in the contempt petition number 7 of 2024, which was filed for non-compliance of the directions contained in the order dated so and so, WPC. Since no objection has been received from the respondent, I stand allowed. The opposite party, MS Mousumi Borua, is arrayed as party respondent number 3.
Madam.
Party respondent number 2 in contempt petition dated 7 of 2024. Petitioner will file amended post title before the registry within a period of 1 week from today. I accordingly stand allowed this. Then you write in the contempt petition in view of the order passed in I number so and so. Mousumi Borua is arrayed as respondent number 2. Top petitioner is directed to file amended post title within a period of 1 week from the parent. Issue notice to the newly pleaded respondent by registered post ID within 2 weeks from today. Matter be listed after 4 weeks.
My lord, a date may be fixed, my lord. I'm a retired man, my lord.
Have it on 16th of June.
My lord.
29. Okay, here I am appearing for respondent number 2. Lordship, I appeared for some time to submit. Today I have instructed to appear for respondent number.
Mr. B. Patel for the petitioner, Mr. S.S. Roy is here for respondent number 2. Subjects to be received in recent instructions to appear on behalf of the respondent. We praise for
3 weeks.
3 weeks time to complete with instruction. Prayer made not objected to by the counsel of the petitioner, list after 3 weeks.
Obliged. Some time we going to file affidavit. Last token also no copy was not given.
This is just this my lord, with regard to correction of the prospectus, where my lord, my designation has been in paragraph 9, in page 9, my lord. But the name of the petitioner is my lord, under WBC number pump operator was there. He was actually working as work test Phalasi, my lord, in the PhD department.
Completely different. My lord.
Whose name?
My lord, the page number 9, Shunit Bhushan Mojumdar, son of such and such, pump operator is written, my lord. Page number 9. It has to be work church class. Only this much.
Really not? No.
This in this order.
Yeah.
In the judgment.
Judgment, not in the judgment, my lord, in the cost. It was wrong by us, my lord, in while writing the writ petition, my lord. That in the cost title of the writ petition, and accordingly it was uploaded in the CIS system, page number 9, my lord, under his name is pump operator. But actually he is worked as Khalas.
Yes.
My lord, in the entire petition, they have used the word card pump operator throughout the petition, my lord. Now, how can they say, my lord, that that nomenclature needs to be changed?
Just a notice you issued, my lord, to take instruction whether, my lord, he has worked as or whether the statement was right or wrong, my lord. Actually, he was retired as worked as from Khalasi, and that's why his other pension paper is, my lord, process, but his pension paper is not
You
processed.
get your instruction.
Yes, my lord. Extra copy may be given. My lord.
That instruction will be completed by the respondent. Extra copies of the IAP party.
My lord. Name may be recorded.
Names of all council, Mr. Rai. SKPT.
Correspondent 6.
Yes.
Obliged.
31.
May please. I have for substitution, my
Substitution.
lord.
Any objections?
My lord, they husband not of a testator without receiving pension, my lord.
What is this IA for?
I have for substitution wife 20 as a legal heir.
So you want an order to be passed by the court for substitution?
My lord.
So let us do that first. Mr. D. Bora. Mr. Hardcore, Mr. Rechuliha, and MS.
Tindong on behalf of Kartika.
MS to on behalf of Mr. Arbitrator. Arbitrator Lucas, is to the respondent. This contempt petition, accompanying contempt petition has been filed by the petitioner alleging willful disobedience of the directions contained in the order dated 20 past
18/1/20.
So during the pendency of the contempt petition, petitioner expired. So the present IA has been filed by the applicant who claims to be the legal heir of the deceased petitioner in the contempt petition number 12. Counsel for the petitioner has referred to the next of kin certificate issued by the petitioner. Sorry, by the competent authority. Accordingly, the petitioner, along with the names of the other legal heirs, is substituted in place of the deceased petitioner, late on this Pagar. So, counsel for the applicant will file necessary We'll file amended post title before the registry within a period of 1 week from today. I, accordingly, stands allowed disposal of. In view of the order passed today in I number so and so to contempt petition of so and so, so and so, so and so has been substituted as a legal heir of the contempt petitioner, non-test or paga. Petitioner will file amended post title before the registry. Let matter be listed after 2 weeks. Respondents will meanwhile complete their instructions in the matter and file necessary.
My lord, I am appearing for response number 1. We have filed our affidavit.
If not already filed. Yes.
Only wife, my lord, substitution name of the wife.
Legal heirs we have given, na?
Right.
So we have to give all the name unless you write no objection. You have not
Right.
supplied a no objection.
Okay.
Hello, I have filed this impleadment petition, madam. This I is for impleadment. The finance department may be included as the party respondent number 7, madam. In this case, madam, Protestant madam is the letter of the finance.
Any objection?
No, that's it.
I so and so has been filed by the petitioner praying for impleadment of the filing. The accompanying resolution. Prayer made is not objected by the respondent. So it is submitted that since the prayer made in the writ petition is for a direction from the respondent to relieve the amount straight forward by the petitioner, along with 15% interest per month. The finance department is a necessary party. Therefore, his application has been filed to array finance department as a party responsible. Where having heard counsel for party, since there is no objection by the respondents, the I is still allowed. Finance department represented by the commissioner and secretary, the finance department government of Assam, is arrayed as party respondent number 7 in the accompanying writ petition, the WPC number 12. I, according to that allowed, disposed of petitioner with file amended post title. In the accompanying writ petition, you write in view of the order dated 22 party I number 22. Finance department represented by commissioner and secretary is arrayed as party respondent number 7. So, anyone for finance here? Since Mr. Rachel Liha, counsel is present in court, standing counsel for finance is present in court. His name is, he is permitted to accept notice on behalf of the finance department. So, since the council represents the finance department, notices the waived, however, extra copies will be furnished within a period of 2 weeks from today. The petitioner will also file amended post title to the registry. MS Bora and MS
Sharma.
Sharma appear to the respondent.
In the main case, madam, there is an interim order may be accepted.
Interim order passed earlier in 26th May.
Extended lordship. Oblige your lordship.
33.
Have plead your lordship. The IO for my lord, amendment of this writ petition, my lord, page 6, my lord.
2013 amendment. Now,
My lord, actually, my lord, respondent number 4 and 5 newly, my lord.
issue notice here. Issue notice.
My lord, let them serve as a copy also, my lord.
Mr. R. Road, council is behalf of PWD. Let extra copies be furnished within the course of the day. Evening, the respondents to complete his instruction. The matter is recorded after 3 weeks.
For admission, I have 34.
Please, Lordship, my senior is in the another courtroom. So the matter may be proceeded to.
All right, time being.
Item 35, 41.
May please, Your Lordship, but it relates to my lord appointment on compassionate ground, my lord. Lordship might have a look at page 37, my lord.
Yes.
At the top, my lord, the remaining 11 numbers of eligible candidates proposed for grade 4 post, along with the remaining 3 candidates proposed for grade 3 post, total 24 candidates shown herein below could not be accommodated due to non-availability of the sufficient vacancy, and therefore proposal shall be forwarded to other department as per clause 15 of the OM dated so and so much. Now, they have filed an affidavit, my lord. They said, my lord, they have forwarded, my lord, to other department. Let the process be completed within a time frame, my lord, that direction.
On the basis of that application number 342/25, Lord sir, I dispose the matter, Lord sir. And Lord sir, one thing, Lord sir, kindly consider the case of Debabrata Tiwari. Kindly allow the case of Debabrata Tiwari while consider the case of compassionate appointment cases, Lord.
You have already taken a decision to see if they can be accommodated. Take that
In the case of Debabrata Tiwari,
where have you stated that?
Lord sir, after the judgment of this WPC number, Lord sir, it has been reflected in the para 10, Lord sir. May I read, Lord sir?
Oh.
In the WPC number 342/25, Lord sir.
Where is that order?
Para 10, Lord.
Lordship, have a look at first paragraph 9, Roman 1, my lord. Paragraph 9, Roman 1, my lord. All the application for compassionate appointment submitted by the petitioner shall be considered and disposed of by the concerned DLC SLC on merit by taking into consideration the various guidelines prior to 1/4/2017. In the instant case, my lord, all are 2017 prior, laid down by the state government for compassionate appointment and the judgment of the Honorable Supreme Court and the High Court. Consequently, the rejection of all compassionate appointment by the DLC SLC which have been put to challenge are pending in the Guwahati High Court as on so and so are set aside.
Kindly peruse the para 10, Lord sir. Para 10, Lord. May I read, Lord sir? It is made clear that in view of the concern of the parties, the court has not gone into the merit of any of the petitioner case are being disposed of by way of this order, and as such, the applicant for compassionate appointment should be disposed of by the concerned authorities on merit as they deem fit and proper. The decisions to be taken by the concerned authorities should be based on reason, and the decisions taken should be communicated to the petitioner thereafter. It is directed that while deciding the case of the applicant for compassionate appointment, the respondents cannot take recourse the impugned OM dated for 18/9/24, though the judgment provided therein, that is the case of Debabrata Tiwari Supra, can be considered applied by the concerned authorities. It is again made clear that this order cannot be used as a precedent for cases that are after filed on 4/4/25 and thereafter, and it shall only apply to the cases that are pending before this court on 3/4/25, Lord.
Do you want us to dispose it of in similar
on this light of
similar term?
So far 10 is concerned, my lord, that is, my lord, consideration of application. Our applications are considered, we are found fit, but due to no vacancy, my lord, so our names are forwarded to other department.
No, it is
And
stated in
that process should be
But
done.
the existing law will be applicable.
Yes, my lord, yes.
Be applicable.
Para 10 may be applicable.
All right.
Applicable.
Disposed.
My lord, item number 35 to 41.
Say 35 to 41.
Obliged, but
I'm obliged.
42.
Wait, Mr. Lordship, kindly, we need some time to file our affidavit and to obtain instruction of the Lordship. Instruction awaited in the matter.
Yes. Any objection?
No, no.
Counsel for the respondent prays for further
3 weeks time.
3 weeks time to complete the instruction. Prayer made is not objected to by the counsel for the petitioner, least after 3 weeks.
Obliged.
43 and 44.
May it please the Lordship. My lord, these matters pertains to an appointment of an arbitrator under section 11. On the last occasion, if your Lordship may kindly take up the order passed on 28/03/2025, wherein, my lord, your Lordship was pleased to appoint Honorable Justice Retired, my lord, H.N. Sharma, and we have taken steps accordingly, and he has consented to the appointment. I'm just placing his consent letter in all the 3 cases.
Third, pursuant to the order dated 28/3/2025. Right, by order dated 28/3/2025, Justice H.N. Sharma, former judge of the Guwahati High Court, appointed by this court as an arbitrator to decide on the disputes arising between the parties in respect of the arising between the parties. So this order of appointment, however, was made subject to the written declaration required to be furnished by prospective arbitrator under section 12(5). So the matter was fixed on 5/5. Thereafter, when the matter is called up, counsel for the petitioner has placed before the court the written declaration by Justice H.N. Sharma, former judge of the Guwahati High Court, expressing no difficulty or handicap in acting as an arbitrator as appointed by the court to decide on the disputes and differences arising by and between the parties. So, in view of the written declaration being placed before the court, the appointment of Justice H.N. Sharma, former judge, as the arbitrator, sole arbitrator, to decide the disputes and differences arising by and between the parties in connection with which agreement?
My lord, this has arisen out of the NIT dated 14/9/2021.
Page.
Yes, my lord. NIT. At page 115, my lord, details are given. 115.
Where is the agreement?
But agreement is subsequent to that. From page 108, my lord, it starts.
Pursuant to the agreement executed by the in connection with contract number GEMC hyphen so and so, so, page number 108. The appointment therefore made earlier by order dated 28/3/2025 is hereby confirmed. Parties are directed to appear before the arbitrator. When?
Maybe, my lord, subject to what my learned friend said, we need a substitution.
On so and so date.
After
Why don't you give a date?
2 weeks.
Give a date.
A date.
not weeks.
Yes. Date will be, my lord, 20, 30, 28/2/8 May, my lord.
28.
Yes, May.
28 May. Before the learned arbitrator, and thereafter the learned arbitrator appointed by this court will commence the arbitration.
Yes.
As per the procedure prescribed. Petitions accordingly disposed of. Copy of this order shall be placed by the parties before the arbitrator. And registry will also communicate a copy of this order to the learned arbitrator appointed. Yes.
I'm highly obliged, my lord. In the next item, my lord, contract number would be different, my lord.
These are three matters.
There are 3 matters, my lord. Item
You give the numbers 44, 43, 44, 45.
I'll just give the numbers.
You give it in a piece of paper
Yes,
in respect of all the 3 writ petitions, contract number,
yes,
date of contract.
yes. I'm highly obliged.
May I please, Lordship? Here affidavit is ready and it is sent for getting, Lordship. Kindly 2 weeks time required.
What happened in this case, my lord? The petitioners participated in the recruitment process for the year 2022, my lord. Result of the said examination was declared on 28/23. Petitioners' result was withheld for verification of their biometric data, my lord. Since 28/2023 till date, my lord, they have not completed the verification, my lord, and thereby we are depriving to get the appointment.
Let them file their affidavit.
Almost 2 years, my lord.
They are praying for 2 weeks.
2 weeks, Lordship.
Date may be 6 minutes.
The later affidavit. Why we need the prayer filing the affidavit. We pray for the time. That the appointment of the petitioner has not been the petitioner is praying for the relief with respect to the appointment. The petitioner is claiming her appointment pursuant to the result declared in the year. And the matter be of 28 May.
Obliged, my lord.
May we please, your Lordship. Lordship, matter may be possible for time being, Lordship. My senior relates in court number 22, Lordship.
I pray for some time to have that.
No, Lordship, my senior, let my senior come, Lordship.
Right.
Lordship, awaited for instruction, Lordship. A communication was has made, Lordship. 2 weeks time.
Counsel for the respondent, Mr. J.K. Goswami, reduce this prayer for further time.
Lordship, the date may be fixed.
Counsel for petitioner, Mr. Public for the prayer may please begin on 28 May.
Obliged.
Take appears for respondent 1. Revenue.
Lordship, 1, 2, and 3.
1, 2, and 3.
May please, your Lordship. My lord, matter relating to the my lord, non-payment of family pension. Here in this case, my lord, the case is covered by Syed Muhammad Fazlur Rabbi's judgment. The petitioner has been appointed on my lord 14/11/1960, and he retired on 28.
Where is that calculation?
My lord, the calculation is part as my lord.
92.
My lord, 6 seat is page my lord.
Page number 92.
My lord, retired on my lord 2001.
Page number 92.
Page number, my lord. Page number 92. Page number 92.
Yes, Mr. Kumar. Same order.
Lordship, they hear your lordship. So far as the claiming of claim to the area, would like to refer the Supreme Court decision.
Supreme Court decision is irrelevant now. The matter has traveled to Supreme Court and
That case was defined, your lordship. In the that case, the deciding point is from which date it will be counted.
Correct.
It says that from the date of initial appointment.
Correct.
It is silent about giving the benefit of area or
You have-
interest thereon.
you have to. This is pension.
Your lordship will kindly.
This is pension.
And the case is covered on page 103, my lord. Judgment is my lord, I have enactment.
Yes. It's for it is on a different ground, certain thing. Okay.
I would like to refer to paragraph 7 and 8. You know.
Yeah. It
Seven and
goes
eight,
against you.
You know,
It goes against the department. You read the first opening lines of para 7.
paragraph 7, your lordship.
Yeah.
To summarize, normally a belated service or related claim will be rejected on the ground of delay in losses or limitation. One of the exceptions to the said rule is cases relating to a continuing wrong, where a service-related claim is based on a continuing wrong. Relief can be granted even if there is a long delay in seeking remedy, with reference to the date on which the continuing wrong commenced, if such continuing wrong creates a continuing source of injury. But there is an exception to the exception. If the grievance is in respect of any order or administrative decision which is related to or affected several others also, and if reopening of the issue would affect the settled rights of third parties, then the claim will not be entertained. For example, if the issue relates to payment or reflection of pay or pension, relief may be granted in spite of delay as it does not affect the rights of third party. But if the claim involves issues relating to seniority or promotion, etc., affecting others, delay would render the claim stale and doctrine of losses and limitation will be applied. Insofar as the consequential relief of
How does
recovery
it
of
help you?
Your lordship.
It goes against you.
Your lordship, kindly the
We'll come
last
back at
part.
we'll come back at 2 p.m.
Yes, sir.
It becomes a continuing wrong.
Yes, sir. Lordship.
In that case, this delay factor will not be applicable.
Your lordship, here also, your lordship, he was claiming pension. Is the service?
He was claiming pension on the basis of a law laid down by this court, which is upheld by the apex court. It was incumbent on the department to take an exercise and decide on matters of all persons,
Your
or
lordship,
maybe issue appropriate
Your
notification.
lordship, that in the death SLP, your lordship, the so far as the giving the area and the interest thereon, your lordship, that is not there.
No, area.
Simply, it
You
was saying
show us,
that
you show me a law that a person entitled to a pension, there has to be a specific order for grant of arrear of pension. This is not arrear of salary.
Lordship, they kindly, the paragraph 7 and 8 of this document. Your Honor.
7, that is what I'm saying.
The 7, Your Lordship, the last part, Your Lordship, may kindly
No,
receive.
last part is all right.
And the 8, Your Lordship.
Number 1, it is a continuing wrong. Number 2, it does not affect a third party.
Yes, yes.
So
In such a similar situation, what is the law laid down by Supreme Court in this case, Your Lordship? And
yes.
The paragraph 7, the last part, Your Lordship.
Yes.
But if the claim involves issues relating to seniority or promotion, etc., affecting others, delay would render the claim stale and doctrine of lasses oblique limitation would be applied. Insofar as the consequential relief or recovery of areas for a past period is concerned, the principles relating to recurring oblique successive wrong will apply. As a consequence, the High Court will restrict the consequential benefit relating to area normally to a period of 3 years prior to the date of filing of the writ petition. Paragraph 8. In this case, the delay of 16 years would affect the consequential claim for arrears. The High Court was not justified in directing payment of arrears relating to 16 years, that too with interest. It ought to have restricted the relief relating to arrears to only 3 years before the date of writ petition or from the date of demand to the date of writ petition, whichever was lesser. It ought not to have granted interest on arrears in such circumstances. That is the law. Here, Your Lordship, the petitioner retired in the year 2001. And now, after about 25 years, Your Lordship.
If you place a law, you have to also read the attending circumstances.
Your Lordship, almost
This is
similar,
a,
Your Lordship, here.
no, this is a case where the man prayed for disability pension.
Yes, Your Lordship.
This is not a case that he is claiming the benefit of a judgment given by a court. There's a difference. He is claiming his disability pension and arrear in this writ petition, Darshan Singh.
Yes, yes.
That was rejected in so far as the arrears are concerned.
Yes, sir. In the data, single bench is rejected, division bench allowed according to state deferred appeal, and in the
What was the claim? Claim was for the area disability pension.
Area disability pension because he was working in the
that issue of whether he is entitled or not entitled was not decided by a court earlier. In this case, this matter had been decided by a division bench of this court. The judgment has been upheld, where the law laid down is that they are entitled to their
Yes,
pension from the date of
Your Lordship,
effective appointment.
in that SLP, Your Lordship, they may read the operative part, Your Lordship.
Yes.
We are therefore of paragraph
page-
86, Your Lordship.
Page number?
Page 86 of his writ petition. Your Lordship.
Yes.
The last part, Your Lordship.
Yes.
We are therefore.
Yes.
Last but
This is the division bench, not
yes,
SLP.
division bench. Your
Yes.
Lordship. In the SLP, there was no discussion. Simply it was dismissed. We are therefore of the considered view that the benefit of the provisions of the Act, including those for pension and other retirement dues, would be available to the provincialized employees in service on and after 1/10/1991 on the basis of length of their service reckoned from the date of their initial appointment. Next phase. Needless to say, the provisions of the pension rules applicable to the state government would apply subject to the above. Vis-a-vis the provincialized employees who have expired on and after 1/10/1991, the benefits in terms of the Act as well as contemplated by the pension rules would be available to those eligible thereunder. On totality, the considerations as herein above, we find no merit in the appeal. The writ petitions claiming pension and other retirement benefit under the Act stand allowed in terms of the determination made in present adjudication. The concerned state departmental authorities would take immediate steps for computation and release of the benefits claimed to the surviving writ petitioners and or to the nominees family members, etc., who are otherwise entitled under the pension rules to receive this same. Here, your lordship, the content dispute was from which date their pension will be counted. Cut-off date. The cut-off date, this division bench in this writ appeal has laid down that from the date of their initial appointment, since subsequently their services have been provincialized. From the date of retirement, it will be counted from the. So here, your lordship, since the government is giving them to the proportional pension, now this division bench, by way of this judgment, honorable division bench say that no, not the proportionate pension, but the full pension. But so far as arrear or interest thereon, it is silent. Your lordship.
No,
if it is silent, your lordship, definitely you would go for the.
You show me an authority that in a matter of this nature, when the arrears are claimed for, there has to be a direction to.
There was no such claim. There was no such claim in the division bench before this judgment. In this judgment, your lordship. There is no such claim.
No, but the finding of the court is that you are entitled.
Yes, you count the entire period.
Right.
You count on entire period.
It's not salary.
You count entire period.
This is not salary that we are talking about, where you require a specific order for arrears. This is pension. Pension is not a bounty.
Yes, definitely.
It does not depend on your wishes. If he is entitled, he is entitled.
Yes.
You can't say that no, he is entitled from this period, but theoretically he is entitled from an earlier period, but not entitled to areas because there is no specific orders of the
judgment I am relying upon. Here also, it is not the case that he is not entitled to the pension, but the case is that issue is that he is delayed. 16 years delay, and here you also more than more than 25 years delay also.
No. In the case that you are referring to, the question was decided by the High Court. In his case, he is not relied on some earlier decision of the High Court, already decided. This is for the first time it was decided in his case.
Yes, sir.
Which is why the court, the facts of the case say that you are not entitled to arrears. In this particular case, the issue is that you are entitled. Unless you show us a specific authority on the point that notwithstanding specific orders.
And this is in the present petition, the petitioner expired.
All right, we'll take up your point and we'll argue. You want to file a response?
Yes, your lordship.
Yes, file it.
Yes.
We'll take up this issue.
Yes.
Heard learned counsel for the parties. Mr. K4, learned counsel, additional AG, appearing for the state, has raised an objection that the petitioner may be entitled to the proportionate, entitled to the pension as have been granted in other similar matters by writ court in WPC number so-and-so Puzzler P. However, since there is no specific direction to release the arrears of pension, the petitioner cannot claim the arrears of pension after how many years?
25 years.
25 years. He has placed into service the judgment of the apex court in Tarsem Singh versus Soin. Under such circumstances, we permit the respondents to file their complete their instructions and file necessary affidavit. Placed after 3 weeks.
Oblige,
we'll take up this issue.
Highly oblige, your lordship.
I think item number 4.
In the last occasion, when the matter listed matter, the challenge of notification was pending before this honorable court matter, and this honorable court in the meantime passed the judgment matter. Yes. Paragraph 9 and 10, my lord, this honorable court.
We have disposed of
Yes,
four,
Lordship.
5 matters
Yes,
a
yes,
while ago.
yes.
Same order.
Same
All right.
paragraph 10.
All right.
Paragraph
Third is court. This is item number
34, my lord.
left over.
34.
34.
Item 48.
May please your lordship, case relates to compassion and appointment matter.
Hmm.
But he needs 2 weeks time.
Lordship,
A date will be fixed, otherwise case will not come up. Listed, my
I
lord.
pray for some time to for impact on that.
Oh, the respondent needs 2 weeks time.
Yes, my lord,
I
he
thought-
told me. My
I
lord.
thought the petitioner wanted 2 weeks time.
No, my
and
lord,
wondering why.
Actually, this case relates to compassion effort. I want to delay disposal. my lord.
MSK Devi appears for the petitioner, Mr. T. Chaudhary. Learned standing on
2 weeks, no?
PC,
Give me
prays for
two.
2 weeks time. Let the matter be
26, my
fixed
lord.
after 26th.
Or my lord, 2 weeks, then 23.
Let it be on 26th.
Yes, yes, sir.
26th.
I'll realize. Oh,
Not
dear.
23 as agreed to by the parties.
Item 53.
Review.
Lordship,
I
DLC
plead the
recommend Lordship. DLC recommend no instruction for SLC Lordship regarding this matter. So it may be disposed of with the repetition 42 25 Lordship. Para 10.
Para 10.
Para
Okay,
10.
I will- it will be completed. Item 34. 34. Same as 34. Yes. All right, is 4. Yes.
Obliged.
54.
He that is the counsel here, he is under bereavement.
Submitted to the prayer is not objected by the court. It's after 2 weeks.
Object.
Tapadar for
Respondent 5 minutes.
5 minutes.
I am for 1, 2, and 4.
Fifty-five.
Lordship, here I have received instruction. I pray for 2 weeks time, Lordship.
Yes. Any
Yes, sir, we
objection?
fixed your road.
It is submitted that by the studying council PTC, Mr. P. Chaudhary, that instructions have been received. Pray for the time to file the application. You are appearing for?
Respondent number 6, Lord.
That I am for 6. As for respondent, 1 and 5.
1 and 5.
It's after 2 weeks.
Date will be fixed.
26.
26.
Evening.
Item 53.
May it please your lordship, we have filed affidavit in response to the affidavit filed by the respondent number 1, 2, and 3 today. And for the respondent number 4 and 5, we may be given 2 weeks time to file reply.
Respondent 4 and 5 have not filed.
We have not filed yet.
You want to file reply?
Yes.
Counsel for the petitioner.
A date may be given if it is not
Prays
incumbent.
for two weeks time.
Which time, a date may be given, Lordship, if it is not inconvenient.
Week's time, file, reply. The affidavit filed by respondent number
4 and 5. Already 1, 2, 3, we have 5.
4 and 5. Submitted. Then reply affidavit. We have the petitioner for respondent 1 with affidavit filed. According to this again on 28th of May.
My lord, this is an application for impeding the applicant at party respondents in the writ petition, my lord. The petitioners, my lord.
You have filed an application. IA.
Yes, IA.
IA.
Yes, IA.
Number lordship
347. Initially, they took time to file affidavit. And
We don't have any objection, lordship may allow the impleadment petition.
Heard Mr. M. Nath, senior counsel assisted by Mr. A. Prachari. And Mr. N. Sharma. N.K. Sharma for
The writ petitioner,
appearing for the writ petitioner, Mr.
U Ghosh on behalf of DP Baral.
Sorry, Mr.
U Ghosh.
U. Ghosh, appearing for the health department.
Yes, Lord.
By this IA, the petitioner seeks to impede. Which respondent?
Respondent number 6, it will be 7, my lord.
Director?
No.
Joint director?
No, for him, my lord.
No. You want to implement as respondent number 7, lordship.
7.
Yes, in the writ petition, there are up to 6 respondents. So this will be the 7th one.
What is the respondent, name of the respondent?
My lord, in the present respondent, all Assam auxiliary nurse, midwife, and lady health supervisor association. Page number 2, my lord, kindly say in my petition, application, applicant.
So you want to implead which respondent?
As respondent number 7, it will be the writ petition.
Which respondent? Which respondent?
No.
He wants to implement as respondent.
As respondent.
You want to be impleaded?
Yes, that's my application.
Has filed an application seeking impleadment in the accompanying writ petition being WPC number 347 of 2025. The applicant claims to be an association, namely All Assam Auxiliary Nurse Midwife and Lady Health Supervisor Service Association, and which is a registered association. The
reason I have given in paragraph 6, my lord, page number 10, it will be page number 11, my lord.
by the accompanying writ petition, the writ petitioners have challenged the resolution
Dated lordship 5/11/2024.
dated 5/11/2023 to the effect that the posts of PHN / DPHN and Deputy Director Nursing under Director of Health Services are to be filled up by way of promotion on seniority basis from ANM cadre. Stop. It is submitted by the applicant that this resolution was on the basis of a memorandum submitted by the applicant association. However, the writ petition was filed without arraying the applicant as a party respondent, and this court had passed an interim order dated 20/12/2024, staying the minutes, operation of the minutes. Stop. Since the application was, since the minutes were adopted on the basis of a memorandum filed by the applicant, the applicant is directly affected and is therefore necessary and a proper party in WPC number 7. Stop. As such, the applicant has filed his application seeking impleadment as party respondent number 7 in WPC number so and so. Better. The respondents do not object to the prayer made. Accordingly, the I stands allowed. The applicant, namely so and so, is arrayed as party respondent number 7 in WPC number 6968 of 2024. Stop. Applicant will file
No.
the
Petitioner will
file amended course title before the registry within a period of 1 week from today. I accordingly stands allowed disposed of. In the writ petition, you write in view of the order passed today in I number so and so. So and so has been arrayed as respondent number 7. And the writ petitioner is directed to file the amended course title within a period of 1 week from today. Since Mr. M. Nath Learned and Mr. A. Bhattacharya Learned Counsel represents the newly impleaded respondent, namely so and so, midwife and nurse association, let notice be issued. However, as the council represents the so and so respondent, notices are waived, extra copies be furnished within a period of 1 week from today. The newly impleaded respondents as well as the other respondents may file their counter affidavit if so advised in a given time.
My lord, along with this IA, I filed another IA for application of interim order. Lordship may fix a later date, my lord.
Matter be fixed. You know, to date.
348 of 25. IA.
And IA number 348, right? This is an application filed by the applicant who has been arrayed today. I already WPC number 7. It's application by application of the interim order dated 2/01/2024 past.
I want to file a reply against the IL.
Is
Any date, future date, I don't know. Anything convenient, your lordship. Give me one date, my.
2nd of June.
My.
Interim order is there.
Interim order passed.
Yes.
Keep the next date of this thing.
Deeply obliged.
Please, Lordship, instructions awaited, Lordship, order 4 each time will be required.
Your Lordship, I pray for a short date, Your Lordship, because what has happened during the pendency of this matter, Your Lordship, on 29/4/2025, they have issued a notice to the petitioner, notice of termination they have issued, my lord. So, whereby, my lord, it is stated that the engagement of the petitioners would be terminated with effect from 29/6/2025, Your Lordship. So there is some very much urgency. The entire matter will be infructuous, my lord. That is why I pray for a short date, my lord. They have acted on the instructions given by this honorable court, but they could not bring the instructions in, your lord.
Letter has been sent, Lordship, but instructions awaited, Lordship.
They have acted on the
Retaliation is
direction
held.
given by this court. Your lord.
Will be held.
Aid us, your lord.
The government would be something to that. Further renew this prayer for further weeks time by counter affidavit. Although the prayer is not objected to counter. What is extended?
Your lordship, they have issued a notice terminating my engagement with effect from 29/6/2025.
It's submitted by the effect from 29/6,
your lord.
2025. That's a double page. It's on 28.
Can it
May.
be a
28 May
28?
20
20.
28 28
28.
28 May.
Published.
Lordship, I have two judgments, one of Supreme Court, following that our High Court also passed one judgment, Lordship, that saying that the minor son of second wife has right over the pension, Lordship.
Yes.
SCC Lordship, para 14 and 15. Following that judgment, this Honorable Court also passed an order.
Yes.
Minor son, how he become a son minor?
Huh?
Because the second marriage is really don't know. Second marriage, here the second marriage is during the substitution, the first marriage, my lord. And the, because there cannot be a second marriage when there is a
Who is
substitution.
challenging that? There has to be a finding.
There only the petitioner, only the second wife is before the lordship.
No, but a child born out of second marriage or no marriage is also a child.
Yes, that is.
That right you cannot take away.
No, here is here the person in the Hindu marriage act also is violates that.
The question of second marriage will come when the wife makes a claim that I have some claim to this or I am also entitled to maintenance or something.
By now the first wife has already expired. That is on 2016. That is expired. He says that he entered into marriage in 2014 when the first marriage was in existence. And this is in violation of Hindu Marriage Act as well as the succession of
I have annexed the birth certificate,
Yes,
Lordship, from which
and the
this
other
is-
person, first marriage, the son from the first marriage also is
He's a major son, Lordship.
he's a major. He is also given a
minor.
birth certificate. Madam.
He is not minor, Lordship. My son is the only minor who has claim over the pension, Lordship. First wife expired. Petitioner is praying for only share of her son only, not praying for entire amount. Still he is attaining majority. He is 9 years old now. Para 14 may kindly be seen, Lordship, of Supreme Court judgment.
What are you claiming? Pension.
Only pension. Other benefits they have the first son from first wife has already taken. Petitioner has no claim over that.
There are other judgments pursuant to this.
Yes, sir.
Lordship. She's just claiming that his portion of pension, his portion, my being a minor son, for survival of his survival. Lordship.
He's working. What is the department?
Department, Lordship, municipal James.
Was in municipal corporation, GMC. And this is that in the marriage is illegal, my lord. In the substance of the first
There
wife.
is a
There is a regulation, my lord, 2015-14 regulation.
There is a regulation.
There is a regulation.
It prohibits.
Almost similar to the pension code, my lord. It doesn't come under the compete of the family, my lord.
2022, our Honorable Court has followed the judgment of Supreme Court, Lordship. May kindly be seen. Our judgment, our High Court's judgment, reflecting, entitlement of the minor son from second wife.
I have also two judgments, my lord, where the says that the petitioner has illegitimate side is only entitled to DCRG, as well as when the marriage itself is in violation of the Hindu Marriage Act, they are not entitled for any pension.
The judgment.
The 2022 2 GLC, my lord, division bench, page number 371, my lord, where the marriage itself is the marriage itself is in violation of Hindu Marriage Act, my lord. The petitioner is the marriage itself is illegal, my lord. That is not entitled for any.
This is regarding spouse, second spouse.
He is second.
No,
She's
I'm
not
the
claiming.
No, she is the petitioner.
petitioner's
Manaswamy
wife
is
is
not a party.
petitioner
Manaswamy is not a party.
petitioner is the second wife, lordship. She's saying that she's praying, but they are saying since you are second wife, but I'm in the petition. I stated that I have a minor son, lordship. We are in difficulty.
Manaswamy is not a
So I-
party.
So then you'll have to file it in representative capacity that you are claiming on behalf of the minor son, not on your behalf. You are the second wife, you can't get.
Single petition.
Lordship can specify that the only son is my entitled, lordship.
Provided a prayer is there.
There is no prayer, not a party.
You have to make a prayer.
Lordship, I have prayed for I have made prayer for pension, lordship. Lordship, may kindly see. Petitioner is the guardian of his her minor son, lordship.
You see page number 11. Prayer.
Yes, lordship. Payment for
You
pay
are saying, see, prayer number 1, directing authorities to pay family pension to the petition.
Yes, Lord.
Release
Petitioner
your
is the mother of their minor son, lordship.
but direction to the petitioner will be your first will have to establish your entitlement.
Then in that case, I will file an additional affidavit.
You have to
Amend the whole contract post title you have to amend.
You have to
Because
amend it. You'll have to file it. You'll have to file an amendment if you want, or you'll have to say that you are entitled to it in you're appearing before the court claiming the right of your minor child.
Lordship.
and the minor child should be the primary petitioner, my lord, represented by the guardian. Here the petitioner, second wife has come.
Admitted, I am admitting that I am second wife. I have a son, lordship. I have annexed the birth certificate saying that myself and my son is, facing hardship, lordship.
So what is your objection to payment of pension to the minor son?
The marriage itself, second marriage itself is illegal. My lord, it is violation of the Hindu Marriage Act. That's why, my lord, and it doesn't come, the second son doesn't come under the ambit of the definition of family.
Where is that?
My lord,
Is it enclosed here?
my lord, that act, my lord, no.
No, there are rules or regulations.
No, there is not included. My friend has an entire bunch of it comes under section 50, rule 55 of that particular regulation, my lord.
I have this. The flag mark is the 25, lordship.
55 is the
55.
is the regulation. Lordship will see 57 definition that the what is the this is the 57 is the family. Family will include the foreign relatives of the employer, the wife in case of the male employee, husband in case of the female employee, minor son, and unmarried minor daughter.
This notification of 2015, lordship. Thereafter, this honorable.
Minor son means what?
Minor legitimate the marriage which has been substitution, my lord. Second marriage itself is in violation
You are
of
mixing up two things. One is the status of the marriage. We are not deciding that. There is an admission that it is a second marriage.
even the
It may be a voidable marriage.
Yes.
What else?
and there are decisions also, my lord. I hand over another decision, my lord. The illegitimate son is not entitled to pension. He is only entitled for death term retirement gratuity only.
You give us all the judgments, you bring it on record.
This is 2015.
Day after.
Oh, lordship.
Day after tomorrow.
Day after tomorrow is holiday, Lord.
That's not from seven.
Stay, Lord.
Thursday, based on Thursday. The councils will furnish the list of citations, decisions which they seek to rely on to the court master.
In respect of item number 64, your lordship, I have looked into office code dated 2/5/2025. As per that office code, it is reflected that item was a track record of the item. It is stated to be delivered. In view of it, my lord, service is completed. And in fact, my humble prayer to lordship, since the service is completed, the person is going to be retired by 31st. Can it be on Thursday, my lord? It'll take a little, because pleading has otherwise completed in the first petition. The stand of the state respondent is disclosed here, my lord.
Lordship, we are entered appearance of respondent number 4. Today we filed to collect.
When is the person retired?
The respondent number 4 is going to be retired by 31st. That is why there is urgency on my part, and state has already filed their stand in the house item that is annexed to the petition in the present petition number 64. So my humble prayer, otherwise the entire matter
Let us have it on 13. 13.
1-3, my lord. My lord. My lord.
Sir, UK Goswami appears to the MS
F. Begum on behalf of S1.
F. Begum on behalf of
S1.
F. On behalf of the right. 1
Right.
1, 2, and 3.
For 1.
2 and 3.
2 and 3.
Respondent 4 is now represented. 5 here. Affidavit. If we complete their file, can say the affidavit. Invite view of the prayer made by that needed for 4 is retiring, limiting office on
31st of May.
He has expressed the matter be displayed on 13th.